Good morning, everybody. Happy December. Welcome to the Courtroom Files Live. Good to have you all here. Let's start off with Judge Middleton. Let's see if he's got a good story about a snowy bridge or something like that.
You had a charge of domestic violence. You were set for a pretrial with the attorney Ross Truckee to represent you on Friday afternoon, this Thursday, December 4th. You failed to appear, he was set to represent you on October 30th. You didn't show up for your hearing on October 30th. The bench warrant issued and you got arrested over the weekend. When did you get arrested?
I was just brought in on Wednesday. I've been in rehab, and I went on my own. I didn't tell anybody I went.
Where'd you get arrested on Wednesday?
At my house.
On Fawn River Road?
No, I wasn't on Fawn River Road. I was on 300 South 4th Street.
Did they come there specifically to arrest you, or did you have just some other reason to have contact with them?
They said they came there because I had bench warrants and they were shining flashlights in my face and told me to come out front.
All right, well, very good. Get the case back on track. I'm going to set this for a last pretrial with attorney Truckee for this Thursday. He's set to be here that day, 12/4 at 2 o'clock. Bond is now $1,000 cash or surety. You also failed to appear for arraignment in a charge of malicious destruction of property. Take a look at that. That is file number 251958. In that case, the allegation is that you were in the village of Colon and you damaged some vehicle tires, which belonged to Katie Brandy's, and you had been in a dating relationship. Injury of more than $200, but less than $1,000. I can attest, having just bought 2 new sets of tires, that a set of 4 tires can be well over $1,000. Anyway, that's the allegation. They allege that it happened on August 30th.
If I may, I did go in and replace all 4 tires. If that means
well, don't say
anything.
any more about it. Show a plea of not guilty. I'm going to appoint Attorney Rhonda Ives. And set an attorney pretrial for January 1st. I can't go that far out. For December 19th. At 8:30. Bond in that case was also set by the magistrate at $1,000 cash or surety, actually set by Judge Pattison. He did show up for your arraignment. Where did you go to rehab?
In Kalamazoo at Enlightened Recovery.
What's the name of it?
Enlightened Recovery.
Lang's Recovery?
Enlightened.
Oh, Enlightened.
Yes, sir.
Well, that's a plus. All right. And we got one more. File 25-2303. Charge of retail fraud in the 2nd degree. In that case, it's alleged you were at the Myers store on October 12th, and you stole some stuff, and you had a previous offense, making it a 2nd degree retail fraud. That's punishable by up to a year in jail and a fine of up to $2,000. Excuse me. Hoping before January 1, I won't be sick anymore. Gotta stop hanging around with little kids.
Yeah.
All right, I'm gonna show you a plea not guilty on that. Show a plea of not guilty. I'm going to appoint an attorney, set attorney pretrial again for December 19th at 8:30. If I code to December 2nd, it's more than 28 days from the day you got arrested. So I'm going to accelerate this up to December 19th. So you got 3 set bond at $1,000 cash or surety. You're not to go to Myers. When did you get out of rehab?
I got out of rehab on probably, I'm just spitballing here, I think it was roughly the 15th.
Of what?
November. I went on November 3rd.
All right. Well, you never bothered to call your lawyers or the court or show up or anything. So now you're sitting in jail. Mr. Truckee represents you in the first case. We'll deal with that this Thursday. Maybe they can address everything on Thursday. The other two
Almost
cases,
half.
Señor, lo que está
a little later. That would be December 19th. All right, Mr. Gowan, you're good to go.
Thank you.
Showing my professional hosting skills right there as I did an accidental switch to another feed. Sorry about that. But now we're going to do a purposeful switch. I'll stay in Michigan. Let's go say good morning to Judge Oakley.
Mr. Bennett, what do you got ready?
The first one would be Chirino, Your Honor, Jorge Diaz.
CHIR.
Got it. Appearances, please.
For the record, Your Honor, James Bennett appearing on behalf of the airport.
Buenos
believe-
días.
Go ahead, ma'am.
Good morning, Your Honor. This is Celine Yu, Spanish interpreter for Mr. Chirino Diaz.
Would you raise your right hand for me? Do you swear or affirm that you will accurately translate between English and Spanish, Spanish and English, so that we can all discuss this file today?
I do, Your Honor.
All right, let Mr. Chirino know what we just said.
Buenos días, señor Chirinos. Estamos en la causa de la fiscalía en su contra. Se acaba de presentar el fiscal James Meme.
Mr. Mena, what do we got?
Your Honor, I had an opportunity to speak with Mr. Chirino through the interpreter. He's going to plead guilty under 771 for 3 months, Your Honor, to abandon personal property.
Y sí, dígame, señor fiscal, qué es lo que vamos a hacer el día de hoy. Dice el señor fiscal, juez, yo tuve la oportunidad de hablar con el señor Chirino. Él se va a declarar culpable a dejar abandonar su propiedad personal bajo el código 771.43.
Mr. Chirino, do you understand your rights and options?
Señor Chirino, ¿usted entiende sus derechos y sus opciones?
Sí, yes.
Yes.
Do you understand the possible penalty for today's charge?
¿Y usted entiende las posibles sanciones por la acusación del día de hoy?
Yes.
Understanding all of that, are you pleading guilty today freely and voluntarily?
Y después de haber entendido todo eso, ¿usted se quiere declarar culpable de una manera libre y voluntaria?
Yes.
Mr. Mena, you'll have to explain to me how this works.
Señor Mena, por favor, explíqueme qué es lo que vamos a hacer específicamente.
I'm not sure, Your Honor. He left personal property airport in violation of the airport ordinance.
Yeah, so how does leaving his phone somewhere help him out? I don't understand that.
He did it intentionally, Your Honor. What it does is it keeps him in the Uber queue. So the phones are geolocated. So
Yeah. That's what I thought. Okay. All right.
Sí, a ver, explíqueme. Bueno, dice el fiscal, lo que pasa es que él dejó su propiedad en quebranto de las leyes del aeropuerto. Él básicamente dejó sus teléfonos para mantenerlo en la línea de una manera intencional. Dice el juez, muy bien, entiendo.
All right, Mr. Chirino, on September 17, 2025 at Detroit Metro Airport, did you leave personal property unattended?
A ver, señor Chirino, dígame, el 17 de septiembre del año 2025, ¿usted dejó propiedad personal abandonada en el aeropuerto de Detroit?
Sí.
Yes.
Mr. Mena, are you satisfied?
I am, Your Honor.
Señor Mena, ¿se adhiere a esto? Dice el fiscal Mena, sí, su señoría.
All right, Mr. Chirino, I have accepted your plea. Anything you want me to consider before I sentence you?
Bueno, señor Chirino, yo voy a aceptar su declaración de culpable. ¿Hay algo que usted me quiera decir antes de que yo le diga su condena?
Bueno.
No.
No fue algo que quise hacerlo intencionalmente, porque fue algo por una necesidad que lo hice, pero bueno, sí acepto que tengo la culpa de haberlo dejado.
I was guilty, I did it as a necessity, but I agree, I am guilty.
All right. I will delay sentence for 3 months. During that time period, stay out of trouble, no new charges.
Voy a poner su condena en suspenso por 3 meses. En esos 3 meses, por favor, no se meta en problemas. No quiero que lo acusen de nada más. ¿Está bien?
Muchas gracias.
Thank you so much.
Court costs are assessed in the amount of $300.
But you sent him down already. You already signed the waiver paperwork. Did you not want him to?
Thank you.
Today.
¿Eso lo puede pagar usted el día de hoy?
¿Pudiera pagarlo el próximo lunes?
Can I pay it by next Monday?
Yeah, say Monday, a week from today, 3 p.m.
Sí, una semana desde el día de hoy hasta las 3 de la tarde.
Ok, muchas gracias.
Okay, thank you so much.
You're welcome. Any questions?
De nada, ¿alguna pregunta?
En 3 meses tengo que volver. Después, ¿qué tengo que hacer?
Do I have to come back in 3 months?
No, just stay out of trouble and it goes away.
No, simplemente no se mete en problemas y eso se desaparece solo.
Ok, muchas gracias.
Okay, thank you so much.
All right. Thank you, Madam Interpreter.
Thank you, Judge.
Thank
you.
Mr. Mena, who's next?
Luke Markle, Your Honor,
Markle,
with an M, yep.
appearances, please.
James Mena for the airport, Your Honor.
Luke Markel here.
All right, Mr. Markel, are you going
Yes,
forward
sir.
today without benefit of a court-appointed attorney?
Yes, sir, Your Honor.
All right, you met with Mr. Mena?
Yes, sir, Your Honor.
What did we come up with, Mr. Mena?
Your Honor, it's checkpoint violation. It's a firearm. He's going to plead guilty under 771 for 3 months. At the completion of the 3-month period, he can contact the airport police and get his firearm back.
Thank you. Mr. Markel, you understand your rights and the options those rights present to you?
I do, Your Honor.
You understand the possible penalty for today's charge?
I do, Your Honor. Yes, sir.
Understanding all of that, are you pleading guilty to the charge freely and voluntarily today?
Yes, sir, I am, Your Honor.
Mr. Markel, on October 24, were you at Detroit Metro Airport?
Yes, sir, Your Honor.
And did you find yourself at a checkpoint?
I did, Your Honor.
Did you have a weapon in your possession at that checkpoint that you were not authorized to have there?
I did, Your Honor.
And that was a firearm.
Yes, sir, Your Honor.
Satisfied, Mr. Mena?
Yes, Your Honor.
So am I. Mr. Markel, excuse
Yes,
me. Any prior criminal history?
I do, Your Honor.
Pardon me?
Yeah, yes, sir, Your Honor.
Hold on a minute. I got somebody talking I don't need to hear. All right, when was your last criminal conviction?
Upwards of 10 years ago, I do believe, sir.
Okay. And are you working?
Yes, sir, Your Honor.
Where do you work? How long have you been employed there?
6 years in January. I own Wholesome CBD and supplements. A family-owned and operated business. I'm full-time there.
All right. And your CPL holder?
Yes, sir, I am.
All right. Anything else you want me to consider before I set the terms of sentence?
Yes, sir. I'm also a coach in jiu-jitsu, and I do my best to help people. I'm a member of church, and I'm very sorry for taking up the taxpayers' dollars and slowing up the line that day. And absolutely, it'll never happen again, sir. Absolutely not.
Yeah, it's usually quite an eye opener for people to get caught.
Yeah, I'm sitting there looking at the screen, and I'm like, oh well, there's the holdup, and I'm like, oh my goodness, and I told the TSA person right away, that's my revolver. It's loaded. I'm so sorry. It's on the third pocket in. I travel for work. And do events. Sometimes I'll have a couple of $1,000s on me, and so it's safe for me to have that. And that event that weekend, I didn't get home until about midnight on Sunday, and I normally take it, put it right in the safe. And Your Honor, I don't know. I had a crazy week that week. 6 a.m. training, and then straight to work, and then training after. It's 6 a.m. to 10 p.m. is what my schedule is currently for a big tournament that's coming up. And that Tuesday, and then the Wednesday, it was church, and then we were actually on the cleaning schedule, so I didn't get home until almost, it was like 11:30, 11, right around there when I got home. And then Thursday back at it, and then Friday morning, I mean, I packed my backpack, just running low on sleep, and it was an absolute, just, I'm so sorry, so sorry.
All right, I'll accept your apology. It happens a lot more than people realize. So for 3 months, stay out of trouble, no new
Yes,
criminal
sir.
offenses. Your court costs are assessed amount of $500. Can you pay that online today?
Yes, sir, I will. Yes, sir.
All right, go to our website, follow the prompts. Enjoy your day.
Thank you, Your Honor. Thank you, sir, prosecutor, sir.
Good luck, sir.
Thank you.
That's all I have for now, Judge. I'm gonna go into my break
All
room.
right, you know where to find us.
Have a good.
Camera's out, Judge. I think he has a couple.
Mr. Jadala, what do you got?
We're ready on Atwell and Pace.
Atwell and Pace, P-A-S-C-E?
PACE, correct.
Thank you. Let's start with Atwell.
Your Honor, respectfully, Sam Rajadala, P62186, appearing on behalf of Mr. Atwell. Your Honor, for purposes of arraignment, we'd waive formal reading and stand mute. Purposes of pretrial, Mr. Atwell would like to avail himself to the plea, whereby he'd be pleading guilty to the checkpoint violation and will be taken under advisement under 771.1 for a period of 3 months, Your Honor.
All right, Mr. Atwell, can you hear me?
Yes, Your Honor, I can.
Did you discuss your rights and options with Mr. Jadala today?
I did.
Understood those rights and the options presented?
Yes, Your Honor, I do.
And sir, do you understand the possible penalty for the charge?
Yes, I do.
Understanding all of this, are you pleading guilty to that charge today freely and voluntarily?
Yes, Your Honor, I am.
All right, Mr. Atwell, on November 10, 2025, did you find yourself at a checkpoint at Detroit Metro Airport?
Yes, I did.
At that time, did you have something in your possession that you did not have authorization to have there?
Yes, Your Honor.
And what was that, sir?
It was my former off-duty Glock pistol.
All right. Satisfied, Mr. Jadala?
I'm satisfied, Your Honor.
This was a 3-month?
3 months, 771.1, correct, Your Honor.
Thank you. What should I know about Mr. Atwell before I sentence?
Your Honor, this was just a slip of the mind. He's a retired DEA agent, Your Honor. He understands he made a mistake. It was an accident. It's not going to happen again.
And the embarrassment alone didn't kill you, Mr. Atwell.
It came close.
I bet it did. I bet it did. Yeah. All right. Anything you want to add to that?
No, Your Honor. It's just it was a complete oversight. I was not planning on flying that day. My wife and I drove from North Carolina because we bought a house for our handicapped daughter in Jackson, and I had to run home. There was an emergency. My wife made a plane reservation at 6:30 in the morning. I get the next plane out. I grabbed my bag. I thought it had 2 sandwiches and a book in it, and I'd forgotten that I must have left it in the backpack. I had locked it in the glove box of my truck. But driving around Detroit and Jackson, I didn't know if that was a good idea. So I vaguely remember throwing it in my backpack and leaving it in the house where I would have left it. But with all the stress and stuff going on, I just grabbed my bag and ran.
Yep. Yep. All right. Anything else I should consider, sir?
No, Your Honor, no.
All right. I'll delay sentence for 3 months. During that time period, you stay out of trouble, no new charges. Court costs are assessed the amount of $500. Can you pay that online today?
Yes, sir, I can.
Any questions for Mr. Jadala before I end the meeting?
How do I go about paying that?
If you just Google, internet search our court, 34th District Court, Romulus, Michigan, follow the prompts, and you'll have the payment options.
Okay. Well, thank you.
Good luck.
Thank you, sir.
Absolutely.
Airport day in Judge Oakley's court. Very interesting. Not something we see every day. But let's go to Texas, something we see more often. Judge Stevens, let's see how December's treating him so far.
Orders. Mr. Cobb represented this gentleman for a considerable period of time, and you just granted the motion to withdraw, and she just got this case, Judge.
I do have all of the video, the media, the
Did you talk to him about all of that? Did you pay him some money? No. It was news to me as of last week. She called me.
I
had no.
He didn't even tell you?
Nothing, sir.
No one informed him, and that was to
Okay.
no fault of his own, but I
No,
wasn't
it's not
able
his-
to make contact with him.
But you retained it.
I did.
Okay. He needs,
Oh.
yeah. Yeah, Mr. Cobb needs to be in here with it. We need to have a hearing on this with him so that it's done the correct way on the record. Sometime this week. Okay. What we were saying, but we're gonna have something this week where I want Mr. Cobb in here to put some things on the record. Because that's just awkward.
Yeah,
It's for him, especially when there was.
It's been a strange.
Retained, that's just, that doesn't make sense. And needs to get cleared up for later problems. Cigar Patel, Patel.
You back?
Judge, I'll grab his Mr. House.
Y'all ready?
No, Judge,
It's 1,000 days old.
He's.
Are you ready though? But you're just.
Ready,
Okay,
especially
all
that next
right,
week, yeah.
that's all I want to know. Okay, Aaron Tyler. That's Bruce Smith. Aaron Tyler, are you good? Have you talked to your lawyer lately? Would you recognize him if you saw him? You would? Is he in the room here? I don't see him either. Can you call him and find out where he is, since it's kind of important to your freedom? You're charged with aggravated assault with a deadly weapon. What is this going to be, a second-degree felony? 20 years in prison, sir. That's important to have a lawyer here. Gonzalo Alvarado.
Like he's coming in Houston. Here, most of them at 10 o'clock.
Came in from Austin, I got here.
I've talked to Mr. McLean, Judge.
This is Alvarado.
Yes, sir.
What about this?
He advised that he's still getting a ruling from the court on a pretrial matter, and
You know what that is?
it's an ex parte motion. I know that. I don't know the extent of it because it's an ex parte motion from the defense, right? But my understanding is that he needs a ruling on that, and had a prior hearing with the court and needed to do some follow-up, and that's why it was set on the stall. Subject to that, the state, of course, is ready. I talked with him last week. He had every intention to be here and resolve it. The pre-trial.
All right. Well, they've gone a little quiet. Let's go down to Florida. Wade Mercer.
Mr. Collette, good morning. Your mother is in the courtroom. Mr. Collette, you're here because you've been accused of one count of criminal mischief. Mr. Collette, there is probable cause for this charge. This type of criminal mischief you're accused of is a first-degree misdemeanor. I'm going to appoint the public defender's office to represent you, Mr. Collette. I'm going to ask that you listen to Mr. McDaniel. Before we do that, ma'am, not only are you his mother, you're also the alleged victim. Is there anything you want to say?
Yes, I would like to
I want to make sure he can hear you also. So if you'll come into the microphone, and make sure he can hear whatever you want to say.
I filled out the paperwork. I want to try and see if I could get him some kind of help because he has some mental issues going on where he sees things and hears things that's not there. And I think that he needs a psychological evaluation with the problems that he's having. I think some of it is drug related. I'm not really sure, but I really feel like that he needs help and not jail time.
Okay.
I just feel like that he needs some help. So I'm trying to do that.
Okay. Mr. Mitchell, any questions for Ms. Collette?
Not at this time.
Mr. McDaniel, any questions for Ms. Collette?
No, Your Honor.
Okay. Thank you, Ms. Collette, for
Thank
coming. So Mr. Collette, let me see if the attorneys have any additional information. Listen to Mr. McDaniel, please.
I don't have anything, Your Honor.
Just requesting a bond.
Yes, Your Honor.
Mr. Mitchell, anything?
We just request a reasonable bond under the circumstances and that he be subject to random UAs.
Okay. Is there, tell me the basis for the random UAs. Was there an allegation of drug use?
Yes, when the deputy made contact with Miss Collette, she was making an allegation that he was on drugs and destroying the house. So allegation of drug use is mentioned in the complaint.
Yeah, okay, it is. Thank you. So Mr. Collette, what I'm going to do is, it looks like you've been to prison twice. Is that right, Mr. Collette?
Yes, sir.
Okay, Mr. Collette, I'm going to set your bond at $5,000 cash or surety. I'm going to have random analysis as a condition of your bond. Cash or surety means that you can go through a bondsman if you wish. Ma'am, what I'm also going to do is ask the jail to get life management to do an evaluation of Mr. Collette. And Ms. Collette, that evaluation may give us some guidance on where we go from here. I don't necessarily have a problem with releasing him to a program if we find the right program. Obviously, I've got to give the state a chance to have input and Mr. McDaniel before making that decision. So once life management meets with him, if they say he would benefit from a program, then the next question is what type of program. There's mental health programs, which are fewer than drug treatment programs. There's drug treatment programs, which we have several of. And then there's programs that deal with both, which are the hardest and rarest, hardest to find and rarest programs. So if it's most programs deal with drugs or alcohol, but not both. And then you have dual diagnosis programs, which deal with both. And those are the ones that are kind of hard to find. So let's see what the life management evaluation says, and we'll go from there. In the meantime, he has the right to a bond. If he posts a bond, or if you post a bond for him, then he'll be out of jail. Otherwise, he'll be there, and we'll see him again once the evaluation is done. So, Corporal, if the evaluation gets done today, and if he's still there tomorrow morning, let me see him tomorrow morning. If the evaluation doesn't get done until tomorrow, we'll see him the following day, the following first appearance after the evaluation. So, Mr. Collette, I'll be seeing you in the near future if you don't post bond. Mr. Collette, there is a condition of random urinalysis on your bond. Do you have any questions, sir?
Yes, sir.
All right, sir. We'll see you soon.
I had worked in a company with life management at one time. He wouldn't go.
The jail will ask them to see him. They have a contract with the county, so they see individuals in the jail. Okay. Corporal, anything else in that case?
No, sir.
All right. The next person that has friends or family here is Thais Pender. Ms. Pender, good morning. Ms. Pender, your cousin Terica is here. Ms. Pender, you've been accused of one count of misdemeanor criminal mischief and one count of felony launching a missile into a building. Ms. Pender, there is probable cause for these two charges. I've also looked at your criminal history, and it looks to me like you've got an outstanding warrant in Bay County. Now, it's the same name, same date of birth, same middle name, so I think it's the same person. So keep in mind, I'm going to set you a bond in these cases today, but keep in mind, I don't think you're going to be released. I'm going to ask the jail to check with Bay County after first appearance and let you know and verify that. But it looks to me like you got a shoplifting charge down there with that from October, an October warrant. So listen to the attorneys, and then we'll address your bond status. Mr. McDaniel, anything?
Ask for a reasonable bond, Your Honor.
Mr. Mitchell.
What's that Bay County case number? If you don't have it, I can just pull it up later.
I didn't write it down.
Then nothing as of right now.
So Ms. Pender, on the misdemeanor, I'm going to set your bond at $5,000. On the felony, your bond's going to be $15,000 because it's a second-degree felony. Your total bond in Jackson County is $20,000. You've got a condition, no contact with the alleged victim, and you're not the alleged victim, correct? Okay, just want to make sure. And Ms. Pender, keep in mind that If you post bond, I'm gonna ask the jail to tell you about the warrant in Bay County before you make that bond decision, because you need to know that before you decide whether or not to post bond. The other thing we gotta do is give you a notice for your court date, Ms. Pender. And that will be, I should have done that on Mr. Collette too.
I think it's 5th or 6th. Give me a second. I can pull it up for you.
Can you,
It's the 5th. It's January 5th.
Stacy, will you make a note? Pamela has her updated sheet. She changed the color combination and I don't have them back yet. I need them back. Please, if you don't mind.
Emphasize 5th for the misdemeanor, 6th for the felony.
January 6th at 8:30 a.m. will be your court date. Ms. Pender, do you have any questions?
No.
Ma'am, in the courtroom, do you have any questions? I just saw it this morning. I looked it up. It was a petty theft and it was an October warrant. I could give you a little more information, give Ms. Pender a little more information if you want. It's the chance of being a different person with the same middle name is really unlikely because of the middle name's an unusual name. So let's see what we got here. I didn't look and see the specifics of it. So Mr. Mitchell, it looks like it's Bay County case.
4796 MM.
Yes. 4796 MM. And the allegations, Ms. Pender, against you in Bay County, Walmart theft, there's allegedly, and it was alcohol, allegedly stealing 2 bottles of Patron liquor, 1 bottle of Deuce or Ducey liquor, not sure how you say that, and 1 bottle of Hennessy liquor valued at more than $100. And allegedly this occurred in Lynn Haven on October 7th. Supposedly it was captured on video. So that's what you're accused of. Any other questions, ma'am? All right. Wish you the best, Ms. Pender.
Okay.
All right. So that's it for friends or family, Mr. Corporal. So let's go back to the top of our list, which is William Chapman.
Good morning, Your Honor.
Good morning, Mr. Chapman. You're here because you've been accused of 1 count of reckless driving and 1 count of aggravated fleeing and eluding. That's a second-degree felony. The first one is a misdemeanor or criminal traffic. I'm going to just tell you there is probable cause in the complaint, and I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel, your attorney for today's purposes. Your Honor, what you said?
Yes, sir.
Mr. Mitchell.
Nothing from the state.
Mr. Chapman, I'm going to set you a bond. I think you're entitled to a bond, Mr. Chapman, based upon the speeds and the location and the driving pattern that's alleged. I'm going to set your bond at $15,000 on the second-degree felony, $5,000 on the reckless driving. Your total bond today, excuse me, is $20,000 cash or surety. Cash or surety means that you do not have to come up with all the money. You can go through a bondsman. That's what a surety bond is. So if you go through a bondsman, what they charge you is something you negotiate with them, but normally it's around 10%. 10% will be $2,000. I'm going to ask the jail to give you a notice for your court date, which will be January the 6th at 8:30. And you will get to use the phone in just a few minutes, sir, to try to post the bond. Do you have any questions?
No.
All right. Wish you the best, sir.
Thank you.
How much did you say? Yeah, I already saw it and looked at it.
No convictions. Yeah. 15.
That's not what it says. Yeah, that's not the one she showed me, though. This one is printed in black and white. Thanks. That's what I need for today's purposes. Next case is Ryan Richardson. Mr. Richardson, good morning. Mr. Richardson, you're here for 1 count of petty theft. Mr. Richardson, I read the complaint. There is probable cause for the charge. Actually, I think I'm the judge that may have signed the warrant, so I found probable cause when I signed it. Corporal, the lieutenant told us this morning that the criminal history was not running out of state records earlier this morning. Is that still the case?
As far as we know, sir.
Okay. So Mr. Richardson, usually I have out-of-state criminal history, and today, unfortunately, I don't have that. So let me ask you a couple of questions. Do you have any charges pending anywhere, Mr. Richardson?
No, sir.
Are you on any probation anywhere?
No, sir.
And when's the last time, if ever, you've been charged with a crime?
I haven't.
You've never been charged with a crime anywhere? Great. And you live in Delville?
Yes, sir.
There's another gentleman by that name, and I assume that when you looked him up, I don't know, I mean, there was a warrant that was issued for him. He was on probation, but it's not the same person. So I assumed, I looked at it and I didn't see anything either. And I was like, you're saying this case isn't the same? No, I'm not saying this case is not that person. I'm saying that there was another person that same name in Florida that was on probation, because it's unusual for you to set a warrant for a second-degree misdemeanor. I think I'm going to read I couldn't open the complaint. Our system was down earlier. And then I'm going to read the complaint since they left that Wednesday. And then he probably was with somebody. And I think there probably was a warrant issue for the other person. Law enforcement asked for a warrant for both. But let's see what we've got here. Oh, it's a really bad copy. Yeah, it says mentions there's at least 2 defendants. Okay. Mr. Mitchell, anything from the state?
Just a moment. I was looking them up too. I didn't see any history in Florida, at least, so nothing at this time.
Mr. McDaniel, anything? Yeah, I didn't see anything in Florida either, but I don't know about Alabama. Okay, Mr. Richardson, I'm gonna let you pick between a bond and a conditional release because of your criminal history and because you're accused of a misdemeanor. If you would like to post a bond, the bond I normally would set for this charge is $2,500. Some people prefer a bond, some people prefer a conditional release. Has he been explained what a conditional release is, Mr. McDaniel? A conditional release is different than a bond. So the way a bond works is you either put up all $2,500 or you go through a bondsman and they charge you an agreed upon fee to get you out of jail. Usually it's around 10% of the bond. That's the way a bond works. Someone in your situation with your history, though, is going to be offered a conditional release. Do you want to talk to him about a PTI resolution if Mr. Mitchell's agree? Or would you rather him come back for arraignment date? Mr. Richardson,
Hold on, John. I think I'd rather bring him back for an arraignment date. That way we can run the NCIC and see
Want to get a
and
written
time
history?
to see if he has anything in Alabama.
No problem. So, Mr. Richardson, a conditional release means you get out of jail without putting up any money. You don't have to go through a bondsman. You don't put up any money out of jail to get out of jail. The trade-off for a conditional release is this: if you accept the conditional release, what happens is that you have more rules to follow than a bond has. So on a bond, you've got a condition not to go to any Walmart, don't miss any court dates, don't be charged with any new crimes. If you accept the conditional release, you have those same conditions, plus you have other conditions. You have to report in by phone once a week. You have a condition not to possess or consume alcoholic beverages. And on a conditional release, you also have to pay a cost of supervision, which is $30 a month. So usually a conditional release turns out being cheaper than a bond, but a conditional release has more rules to follow. That's the trade-off. You're under court supervision on a conditional release, a more intense form of supervision than you are on a bond. So you get to pick if you'd rather post a bond, either by putting up all $2,500 or going through a bondsman, that's fine. On the other hand, if you'd rather accept the conditional release and get out of jail without putting up any money, that's fine too. It's entirely up to you. Do you have any questions about your choice between the bond and the conditional release?
I'll take conditional release.
You want to take the conditional release? Is that what you said?
Yes, sir.
Mr. Richard, I'm going to grant you the conditional release. What's going to happen next, sir, is they're going to bring you to the courthouse because that's where the conditional release is at. So they'll let you get dressed. They'll let you use the phone for transportation to call somebody if you wish. Then they'll bring you to the courthouse because you'll meet with a conditional release officer, Mr. Goodson or Mr. Ham, one of those guys. Once you meet with them, they're going to go over the conditional release with you. They're going to give you a copy of all the rules in writing. They'll give you a chance to ask any questions, and then you'll be free to leave. So if you do call friends or family, you can tell them you can be picked up at the Jackson County Courthouse in roughly 30 to 45 minutes, Mr. Richardson. And lastly, when you get here, they're going to give you a notice for your next court date. They'll get you to sign for that notice. You will not get a notice in the mail. They'll put a notice in your hand. That'll be the only notice you get, and that should be January the 5th at 9 a.m. will be your court date. They'll give you that notice downstairs. Mr. Richardson, do you have any questions?
No, sir.
All right, sir. We'll see you in a little while.
All right.
Next case is Taj Smith. Mr. Smith, good morning. Mr. Smith, you're here because you've been accused of one count of principal in the first degree to first degree misdemeanor of petty theft. Mr. Smith, there is probable cause for that charge in the complaint. I've also looked at your criminal history, which shows you've been to prison twice and getting out of prison in May of this year. I'm going to appoint the public defender's office to represent you and listen to your attorney, then we're going to go from there. Mr. McDaniel.
Your Honor, I've talked to Mr. Smith. He's going to plead no contest. The charge is listed. You understand him? He's been sentenced to 90 days in the county jail. You have 1 day jail credit. There'll be reservation on the restitution that might be owed. And he has signed his plea waiver form, waiving his right to jury trial and call witnesses.
Thank you. Mr. Mitchell, anything?
That is agreeable with the state, Your Honor.
Thank you. Mr. Smith, do you have any questions about that agreement, sir?
What doing it 90 days? I do get game time with this, right?
I can't promise you game time because I don't know how your behavior at the jail is going to work out. What I can tell you is you're legally eligible for game time and most people get it. But that's dependent upon you following the jail rules. As long as you follow the jail rules, then yes, you should get quite a bit of game time. You can get up to a maximum you can get is 10 days per month off of your sentence. Any other questions?
No, sir, there's not.
Is that the plea you want to enter, sir?
Yes, sir.
Mr. Smith, I'm going to accept your plea of no contest to the charge of retail theft, first degree misdemeanor. I'm going to judge you guilty of that offense. I'm going to sentence you to 90 days in jail, Mr. Smith, but you have credit for 1 day you've served. I'm also going to order court costs and fines of $370 in reserve jurisdiction for a period of 60 days. We either got to have an order entered within 60 days, or Mr. Mitchell will need you to schedule a hearing within that 60 days if restitution is not agreed upon. Mr. Smith, talk to the jail after first appearance about the public works program. If that's something that interests you, that's the trustee program you're talking about to get you some extra game time. Mr. Smith, there's no probation involved in this case. You finished this jail sentence, you're through with this case. Any questions, sir?
No, sir, there's not.
Wish you the best, Mr. Smith.
Mr. Smith, let me go ahead and ask you. I mean, so they said it was $582.33 that was stolen. That would be what the restitution amount would be. So if you want to agree to that, then I can just go ahead and do a restitution order on that today. If you don't, then the state can try to schedule a hearing and try to prove it, but if you want to agree to it, it's $582.33 would be the restitution order. And that'll be a civil judgment against you. It's not,
I mean, yeah, I can do that.
You all right with that? Okay. $582.33 restitution order.
And that'll be a civil judgment against you. In other words, Mr. Smith, because you've got a jail sentence, that doesn't increase your jail sentence. There'll be a civil judgment. If you ever win the lottery or if you ever buy or sell real property in Jackson County, it may be collected at some point. But you're that's 33. It's not going to affect your release date at all. Okay.
That'd be joint and severally liable with any.
Well, I can't order joint and several
that get if they get arrested on it.
Yeah. If someone else is ordered, yeah, I will obviously. But as of right now, since he's the first.
Yeah, they just have street names on the other two co-defendants for right now. So
yeah, he didn't know them. That's what the complaint says. So how do we do that if he's the first one sentenced?
Sentence in there that says that if any other defendants are charged with it, then he'd be joint and severally liable.
Yeah, so that's what we need to do. I'm not ordering it joint and several because I don't have anybody to order joint and several with, but you can put a sentence in there that says it will be joint and several if anyone else is ordered to pay it. So what we're talking about, Mr. Smith, means if someone else is charged with this, you may be paying restitution with them, not all by yourself. That's what that means. Okay.
That's fine.
Have a good day, sir.
All right, you too.
Thank you. After Mr. Smith, we have Kim Benson. Since I did not get to this case. Mr. Benson, you're here for a review of the weekend first appearance. It looks like the judge during the weekend first appearance reviewed the case, found probable cause, and set you a bond of $2,500. But when did you brought back today?
He didn't know who the victim was. He couldn't pull up anything on CCIS, so just let him know who the victim is. No contact with.
Hang on.
So the system was down this weekend?
It's been down since last Wednesday, or Jackson County. Every other county is working, but Jackson County is not.
I might be able to give you the name.
So is your understanding that's the only reason Mr. Benson was brought back was to?
Oh, that's my understanding.
To address the no contact condition?
It's Lowe's. It's a business.
So, Mr. Benson, you've got a bond that was set by the weekend judge, and the person or place you can have no contact with is Lowe's. So as part of your bond, you can have no contact with any Lowe's. That's who's accused you of this. Any questions?
Yes, sir.
Have a good day. Have a good day, sir. Corporal, I think that's it for first appearances. Did I miss anybody?
No, sir, you didn't.
Let's see if,
It's the Courtroom Files. It is Monday, the first Monday of December. Happy December, everybody. Hopefully we have a great month, getting ramped up for Christmas and New Year's. It'll be good. Let's go back to Judge Stevens, new contestant.
Alpin, that's you, Al, is Alpin? Yes. Correct, is that right? Your sophomores. Is Mr. Adams your attorney?
Yes, Your Honor.
You were charged in 2 cases, 25 CR 873 and 874 with the first degree felony of aggravated sexual assault with a child and indecency with a child by exposure. First degree felony and aggravated sexual assault, you were looking at up to life imprisonment if convicted, and then the indecency up to an additional 10 years in prison in that case. What are we doing on these two?
Judge Austin was 30 years in prison TDC. He's saying no, that's a trial.
Okay, that's right.
I want to try to fight from Anderson.
Or is that right? You want to try it?
No.
You're not accepting the deal, so it's going for trial, right? That's what, yes? But you only have 2 choices. You're either going to accept the offer or it goes to trial. Which one is it, sir?
You said that you're going to fight for
Which one?
That's what
You have to speak out in English for the record. What is it you want? You've got 2 options here. He's talked to you. I know about it.
necessary. I'm sorry. The question is, you said you want to fight for innocence, but you want a trial or not? I don't want a trial. How you gonna do that?
There's only 2 choices. Pay attention closely. It's either the option of an offer that's been made to accept it or go to trial. Those are the only 2. Huh? Well, over here.
I'm taking it from.
Okay. It's set for trial. This will be we'll set first the aggravated sexual assault, the first degree. Over here is we're over here. We're going to set this for trial. When can you be ready? This is going to fast track. We're going to get this thing done as soon as possible.
Whenever you ready for it, Judge, I can
Can you, Mr. Am, can you be ready in a few weeks?
Whenever you set it,
All right. It'll be ready next month. We'll try it next month. Thank you. That is all.
Thank you, Your Honor.
Next is, I've got Gregory Woods.
Who?
Gregory Woods, that's on. Jacoby Diamond Broussard. Langston, Jacoby Broussard.
Yes, sir.
Citizen.
That's citizen.
Jacoby Broussard, thank you. Jacoby Broussard. No problem. Is it right? We now call 22-39417, the state of Texas versus Jacoby Diamond Broussard. You, Mr. Broussard?
Yes, sir.
Present with your attorney, Mr. Adams, and the state's attorney.
Yes, sir.
Earlier, you entered a plea of guilty to the first degree felony of murder in this case. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it, State
I reviewed it. I have no objections or changes, Judge.
and defense? Then without objection, it's made a part of the record for all purposes here. The agreement is whatever sentence shall not exceed a cap of 30 years imprisonment. So we really are looking at no less than 5, no more than 30 years confinement in prison. I believe there aren't any other options, correct?
Correct, Judge.
Is that the way you understand it, Langston?
Yes, sir.
All right. State, want to go first and last?
I'd like to go last, Judge.
You can go first and last. You can defer. Mr. Adams, go ahead on behalf of Mr. Broussard.
Judge, if you look at page 1 of the pre-sentence investigative report, and I'm looking right above defendant's version, you'll see that it was 3 people that was all charged with murder: Jacoby Broussard, Arthur Small, Charles Moss, and they all were charged with murder. Prior to today, it's my understanding that Arthur Small and Charles Moss has already pled before your court, Judge. And Mr. Helm can correct me if I'm wrong, but I understand that Mr. Small got 8 years, and at that time, Mr. Small was already on probation in your court for another case. And then I believe Mr. Moss, and Mr. Helm can correct me if I'm wrong, I understand he ended up pleading for, I believe, 15 years, 20 years, 15 years, I believe. So what I'm asking, Judge, is if you look, and I'm only looking at page 1, when you look on page 1, Judge, you see specifically where Mr. Thomas was shot at the canal, and then he apparently had got into a fist fight, and I'm reading specifically where it says when he witnessed the fight between Thomas and Trey Moss. Trey Moss was the one who was already in your court, and I believe he took a 15-year deal. He is the one that got into the physical fight with the deceased in this case. And then apparently the deceased came back and there was gunshots. Judge, the thing that we would add to the PSI, and Mr. Helm has already provided this to my office, was the forensic post-mortem examination. And I do not believe Mr. Helm is going to contest that according to Judge, what I was going to tell you is according to the forensic exam, the deceased had a gunshot wound through the right thigh. So he took a bullet to the right thigh. And also it says it was another bullet to the left side of his abdomen. And that's in this report, Judge. Here you go, Judge. I'll just show that he was shot twice. One to the thigh and then one to his abdomen. Okay. So our position.
Copy this.
Yeah. Yeah. So our position, I can make a copy. You can have it.
Got it.
Oh, so what I'm saying, Judge, is that there were 2 shooters, and we believe to make in line with what my client said, where he said in the defendant's version of what happened.
How many times was the complainant, the victim shot?
Well, we know he was shot twice because he was
At least
because one was to the thigh, and that's what I'm looking at right there, and the other one was to the abdomen. So we believe that there was 2 shooters, and with the 2 shooters, and that's revealed, and there was 2 wounds, and I was letting you see where I got that from. It's our position that the wound to the abdomen came from Mr. Moss, and then apparently the wound to the thigh would have been my client, Mr. Broussard. And Judge, if you look specifically, and I'm ready.
Why do you say that?
Because
well, how can you determine that not being present?
No.
And not having any other scientific evidence to support that other than
because he was there.
Okay, it's what he's telling you.
Right, because he was there, because he saw everything. He would have been there. And Judge, what I'm saying,
what is it you're saying his responsibility was? What did he do?
Well, I'm saying with there being with the victim being shot twice, I think, hey, he's a party to the offense. But what I was asking, Judge, is that when you look specifically to his criminal history,
Unlike Arthur Small was on probation when this happened, and he agreed to be a witness for the state to testify against my client. And then unlike Mr. Moss, who's the one that's actually having a physical confrontation with the city, it wasn't my client. And I'm asking if you just read from the PSI, the guy who's the instigator of all of this is Mr. Moss. He's the one that's beating up the man and having a physical fight with him. And he's the one that has more incentive to shoot him than anybody because he got to fight. And our position is that you had two shooters, and that and having two shooters, my client is culpable for firing a shot, but the one who is the most culpable is Mr. Moss. And again, like I said, Mr. Ham can correct me, but I thought, if I'm not mistaken, he received 15 years. I could be wrong, it might be 20, but I know it was not 30 years. And what I'm asking the court is, Judge, is that if the man who we believe is the most culpable got 15, or I know it was no more than 20, then I don't believe my client should get the max out 30 years. And the reason I'm concerned about that is that, Judge, if you look on page 2, I see where the mother went in there said that she wanted him to get 40 to 50 years in prison, and the dad felt that he should get more than 30. But in my opinion, Judge, in arguing on behalf of my client, the person that was most culpable was Mr. Moss. And Mr. Moss did not get a 30-year sentence. And since he didn't get a 30-year sentence, it's not going to be fair for my client to get hit with 30 years when the man who was most culpable was not. And that's why I showed you, Judge, that it was at least 2. There's no doubt, according to the autopsy report, it's no doubt he was hit twice. There's absolutely no doubt about that. One to the thigh and one to the abdomen. And I think that my guy is responsible for the thigh, but he's not responsible for the one that went to the abdomen.
No, you've seen the pre-sentence report.
Yes.
He's not responsible for anything.
No, I didn't say that.
That's what he says here.
Okay. But
he didn't shoot anybody.
No, I hate.
But you're saying he did shoot somebody.
I think that he needs to clarify that. Yeah, he needs to clarify that.
Oh, he does?
Right.
Well, he was pretty clear here in that when he pleaded guilty, which was odd, but then he later admits he didn't shoot anybody. That's his inference here. But you're saying he did, even though you weren't there.
You know, I wasn't that, Judge, but the thing is, like I said, and the reason why I brought that to your attention, just looking at the autopsy report, to suggest that there was 2 wounds, and there's no doubt about that.
I'm not surprised. I'm looking at what all this says. It appears as though 2 people did shoot. That's why 2 people apparently had pleaded guilty.
Right, and it's actually 3 people charged.
But the pre-sentence report, he's trying to play both sides. I'm guilty, but I'm really not guilty. He can't figure out which one he is, Mr. Dr. Jekyll and Mr. Hyde. And that's kind of a problem.
That's why I was trying to reconcile his statements with the objective.
How do you reconcile he didn't shoot anybody who was pleading guilty and he wants to accept responsibility? How does that work? How does it work?
No, I think that he's going to accept responsibility for firing.
But that's not what he says here. When he had a chance, he pleaded guilty under oath, but when he went to talk to the probation officer, he changed direction completely. I mean, being truthful and forthcoming is important. Do you know what happened here? A human being died. A human being, one of God's creatures. You had responsibility with that as well as the other person. But you killed somebody. You feel anything bad about that?
Yes, sir, I do.
Oh, do you? You certainly weren't forthright here at the probation office. You want to just interrupt me?
No, sir.
That's the way you are, isn't it?
No, sir.
I get the feeling you like to control the situation, like you control this shooter. You seem to be the boss.
No, sir.
Well, that's the way it looks.
No, sir, you're the boss, sir.
Well, no, that's the way, and that's not the way this pre-sentence report appears. You want to play both sides. I want to make a deal, but I didn't do it. Can't have it both ways.
No, sir.
I'm gonna let you talk for just a second. I want what Dave have to say.
You ready, Judge?
Yeah, go ahead.
Let me address some of the statements by defense counsel so that we can get on the right page. Mr. Small pled to a lesser included offense of manslaughter and received 8 years TDC. That was all part and parcel of an agreement for him to testify against Mr. Broussard. He stated at the time of this incident and reaffirmed during.
And you feel, by the way, you feel like that is fair and appropriate under the circumstances?
Yes, sir.
Go ahead.
He's stated early on and then reaffirmed during trial preparation that Jacoby Broussard is the only person that shot Christopher Thomas on that date. There was a fourth person that was there. All this is a part of discovery. That individual's name is Ladarius, and he's Ladarius Lofton, and he's been cooperating since the incident occurred. He was one of the 4 individuals in the car, and thanks to him, he came forward whenever this body was found and told the Port Arthur Police Department about the fact that this young man was actually killed. Up until that time, they had not seen the bullet wounds in the body. The body was found in the ditch, but they mistakenly believed that it was some kind of an overdose. Had Mr. Lofton not stepped forward, we never would have gotten to the point where a murder investigation would have proceeded. He was not charged. He was present at the time, and he says again that it was Jacoby Broussard that was the shooter in this incident. So that's an uncharged individual out of this incident, and the reasons why. Arthur Small was not on probation, as defense counsel said. His agreement is based upon his cooperation. The other defendant, Charles Moss, only entered a plea after Mr. Broussard accepted responsibility. He did that on November 13th. He is waiting sentencing. His agreement was a lesser included offense of a manslaughter. Now, this all goes back to, and the whole reason why we're here talking about a cap of 30 for this individual is that factually, Mr. Adams did get one thing right. There were 2 wounds. There's nothing I can prove that there were 2 shooters. There was, we have firearms reports, and the experts were ready to come forward to show that the 2 wounds that occurred on this came from one gun, not from separate guns. So we know that fits with what the other 2 witnesses were prepared to testify, that puts a responsibility on this man for killing Christopher Thomas on that day. There's no doubt that the facts are that Mr. Moss was involved in the situation. There was a fight between Mr. Moss and Mr. Thomas prior to the incident, but there's no evidence other than this man's suggestion that Charles Moss was a shooter. And I agree with Your Honor, as you always do, you honed in on the fact that he wasn't accepting responsibility. He really hasn't done it today. His lawyer has. He stated emphatically in the PSI report that he was there, but he didn't do it, that it was Charles Moss, shifting the blame over to him. The only thing that's good about that is that him making those kind of statements led to Moss accepting responsibility afterwards. But it doesn't step away from the fact of he killed a man. He killed a man that day. He left him there in a ditch, half clothed, shot in 2 different spots, and he's the one that's responsible for it. His parents are hurting. You can read that. Their wounds and their emotions just come out on the pages where you read what their responses are to this. I've dealt with this family from the very beginning of this incident when it first got indicted, and we learned that unfortunately Mr. Adams represented the decedent before this offense occurred. This family has never been satisfied with how the system has worked in this regard. They did approve the agreement that I made, but it was very reluctant, as you can tell by their statements here. I have no doubt as I stand before the court that the man responsible for the death of Christopher Thomas is right before you.
He pulled the trigger. It resulted in the 2 wounds. The 2 wounds is what caused that death. The concession to bring it down to 30, as opposed to the cold-hearted killing that it was, has a lot to do with all those facts I was just going through. There was a lot that was going to get muddy at the time of trial. There was going to be blaming on other individuals instead of accepting responsibility. I thought I had it worked out to where that was going to occur, and then we get his statements here. That being said, nothing has changed. The facts of the case, which are that Mr. Thomas was shot 2 times with the same weapon. In order for it to occur, as defense suggests, there would have had to have been some exchange between Mr. Broussard and Mr. Moss so that one shoots and then the other turns around and shoots. Is that possible? Yeah, it's possible. But it doesn't change the fact that this is the individual that 2 witnesses says killed that man and left him for dead in the ditch. 30 years is what's appropriate.
Judge, one point that Mr. Ham was leaving obvious is that witness, Mr. Small, has made multiple statements. When he first was approached and gave an interview, he said one thing. Then later on in the case, when the DA's office investigated, he says another thing. My only point is that Judge Moss, as Mr. Ham stated, has entered into a plea agreement, and he's saying it's coming back for sentencing. It wasn't a 30-year cap on Mr. Moss. And what I'm saying, Judge, is by way of extrapolation and by way of deduction, when you read the first page of the PSI, it was Moss who had a physical fight with this deceased guy. It was Moss that was the one that was throwing blows with him, punching him. That was Moss. And the deceased came back. So if out of everybody there, the guy, in my opinion, that would have been the most heated, the most angry, is going to be the one who had the physical fight. And what I was trying to say, Judge, and that's why I kept pointing out about the 2 wounds, one to the leg and one to the stomach. You had 2 shooters, and that Mr. Moss is going to leave out of here with what, 15 years or something on the cap that he made for Mr. Moss. What I'm saying is that my client should not get 30 when, if you look at his criminal history, to my understanding, Judge, when you look on the last page, he doesn't have that criminal history at all. At all. He does not. And he did go to Memorial High School. He has had employment. And I think, like you said, Judge, it's best for me to, let him do more talking than me. But all I was trying to get the court to see is that there were 2 shooters based upon the wounds, one to the thigh and one to the stomach. Now, I guess the question for you today is do you accept responsibility for the wound to the leg?
Yes, sir. Take full responsibility. Yeah, they know.
And with that, he's taking. So what I want to do, Judge, is to correct and amend the PSI, because what he is saying is what I said.
Does that kill the man? The wound to the leg?
Well, I think that when you if 2 people
did that kill the man?
I
take it from your silence, you don't have any answer to that. Yeah. Well, pre-sentence report, are there any objections to the pre-sentence report?
No, I'm not going to object.
Then it's made a part of the record for all purposes. According to the authorities that investigated this case, they disagree with you.
Yes, sir.
It is determined that Jacoby decided to fire shots at Thomas, striking him multiple times. After he shot Thomas, they left the scene. And then the next morning is when the deceased's body was found in the canal, left to die.
Yes, sir.
And really, both folks who did the shooting here, the defendant and the other co-defendant, have much culpability since they acted together. The just heinous nature of his leaving this person just to die and walking off as though they had a big meal and we're going somewhere to watch a ball game or something. It just flippant. To treat a human being like that is disturbing, and to change stories through this pre-sentence report, you are not guilty, and then, yeah, but you are guilty, trying to figure a way to manipulate through this without being held responsible. But the investigators who were close to this case and investigated it believed otherwise. Both of you have pleaded guilty. Both of you are responsible for the death of this human being. And the family members are upset that even this limit of 30 years imprisonment just does not seem fair to them. One, the mother states he should get at least 40 to 50 years in prison. None of them called 911. None of them rendered aid to my son. And he was left there to die, and then to be found later the next day. The father of the deceased, he shot my son, made a choice to do that. He should get more than 30 years. But that is not the maximum. And he is disappointed that, as both of them, that you're not being held for more responsibility to taking their son's life, which was a tragic thing here. Anything else to add by the way?
No,
I was just asking too, since the other guy who was the fighter did a cap deal that was what less than the 30 years, and as to my understanding, that cap was around 15 in comparability. So what I'm saying is that I would ask for my clients to be somewhere around that 15 to 20 years as well.
Through investigation, again, the authorities think otherwise about the responsibility of your client. It is determined that Jacoby decided to fire shots at Thomas, striking him multiple times. That's what they think from their investigation. You weren't there, I wasn't there, but the investigators put this together. He pleaded guilty. The other guy pleaded guilty. There's both responsible. Anything else?
I see what you're saying.
Mr. Bruce, anything else you want to add?
I apologize. I'll take full responsibility.
How do you take the life back?
Sure, I wish I can.
Yeah, well, do you think an apology makes a difference to that family?
I sure, and I want to apologize to the family. It didn't happen. It shouldn't happen.
I guess there's not much they can do about it, but they want the child back. Can you do that?
Sure.
You shouldn't have taken it away from another human being. It's not, it was our creator who created it, like created you. You have no right to take it away. You understand?
Yes, sir.
You have to pay a price. You pleaded guilty in this case voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in the plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first degree felony of murder. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 30 years. The judgment shall reflect that a deadly weapon, namely a firearm, was used in the commission of this offense. It will be rendered on the judgment. You will be given credit for all time you have served and have that relationship to this case. This is the sentence. This is what's fair and just. Unfortunately, I would just wish there was something in the law we could figure out how we could bring life back. But it is forever when it's taken away, and you were responsible. That is all.
Well, that's a heavy, sad, all of that kind of stuff case right there. Anytime you have loss of a life. Judge Stevens is definitely dealing with some heavy stuff already today, and he's not in a great mood because the one lawyer didn't show up. But credit to the jail for dressing him in their best available stripes for his sentencing hearing, I suppose. So before we move on, let's talk about today's sponsor real quick. And quite honestly, today's sponsor here at the Courtroom Files is the Courtroom Files. So two things. Number one, courtroomfiles.com. Today is the last day for our Black Friday Cyber Monday sale. 15% off the entire store if you use the code that's displayed at the top of the store. If you are a channel member, you get 25% off anything you order. So if there's anything you got a hankering for, today's the day to do it. I would especially call your attention to the TCF calendar that we have made for 2026. I'm very excited about that. So check that out. And it's quite honestly, I was able to price that in such a way that it's really no different from any calendar you would pick up at a store price-wise, but it's better. So you should get one. The other thing I want to call your attention to, which I have never done here before, as a general rule, we do not cross our businesses. However, I'm doing it right now. One of the main businesses we have here at the TCF Bunker is our handmade jewelry business. It's called Art and Soul. This is our Etsy store for that. We sell in other places too, but Etsy is the main place that we sell. We do handmade jewelry among a couple of other things. So I have many items on sale through today. 183 of our items, to be exact, are on sale. Various percentages off depending on what you get. But the other thing, if you do it today and you use code EXTRA20 at checkout, Etsy is throwing another 20% off your order up to $10. That's something Etsy is kicking in. So we've got good discounts, plus Etsy's giving you an additional bonus. These are wonderfully giftable items that we have here. Everything is handmade, so it's very personal, and it's a lot better than just clicking on Amazon and buying something to give to somebody. So if you've got somebody who's into jewelry, you want to pick up something for yourself, do check this out. I'm going to drop a link in the comments right now so you have it. Yeah, Barbara, I'm getting there. Patience. Let me do my pitch. We'll get there. Link is coming in the chat. All right, let's go back to Judge Stevens, new contestant.
It's like not reporting. It looks like you absconded. You quit reporting in May of 2024 and then just kind of walked off the job.
Yes, sir.
And then they had to go find you. And that's 99% of probation is reporting. You didn't do that. So you're looking at up to 2 years in prison in the state jail and this theft case, and up to 10 years imprisonment on this continuous family violence case. What are we going to do just today?
Well, today, that's the reason why I was asking you for like 2 weeks, and I don't necessarily need to contest it anyway.
Is that all you want? 2 weeks?
Yeah, because
okay,
she's gonna have some.
It'll be reset for 2 weeks.
That'd be
okay. All right, that is all. Thank you. And I've got. Did you have it in the trial docket at all? Did you have anything else?
Maybe not. If that's gonna be too.
Yes, please do the papers. I don't never know.
Oh. Let me get paid.
All right, off the trial docket, what else do we have on dispositions?
Done and signed up, Jeff.
All right, come on out. Okay, the finish name.
Kristen Dunham.
Are both on this?
March. Or the end.
One you holding his legs, the other one holding his arms.
I'm hearing Mr. Roebuck's papers.
You're right on time.
Well, it sounds like
Place it flat right there. Don't
a
roll it.
creative way to handle you.
So
There one more time.
you have to be.
I'm reading. They beat up on me really bad.
Let's stand in front of judge.
Okay, do I have that file?
Sorry.
Just one thing.
Two cases. And this
Is he pleading to two or one?
It's pleading to two, and it's going to be a split sentence. It's going to be pen time on one, probation on the other.
Wasn't gonna be easy today, was it?
No, sir. I was just following your example from years back.
My example. from
Yeah.
years ago.
You used to split sentences all the time. Oh, well. I'll go get on the phone too.
Two cases are called 23 CR 1745 and 1746. The state of Texas versus Tristan Kelly Dunham. Is that you, Mr. Dunham?
Yes, sir.
Present with, is Mr. Roebuck going to be the lead with Mr. Roebuck as your attorney in this hearing? Does the defendant waive a formal reading of the indictment and the arraignment in each case here? Can we proceed with summary? In summary, in 1745, this alleges that, well, they both, let's take them together. 23 CR 1745 and 1746 are individual indictments alleging second-degree felonies of manslaughter in 1745 involving vehicular manslaughter, and in 23 CR 1746, a second-degree felony of accident involving death. Oh, one fatality?
Yes, sir.
Two cases out of this one event, right?
Correct.
All right. Both of these, sir, indictments allege that this occurred on or about August 12th, 2023 in Jefferson County, Texas. And in 1745, the manslaughter, it is alleged that you recklessly caused the death of Christian Michael Sykes by operating a motor vehicle on a public road in excess of 100 miles per hour and failing to maintain control of the vehicle, which struck the rear of another motor vehicle occupied by the victim in this case, causing that vehicle to flip and leave the roadway, which resulted in the victim being ejected from that motor vehicle. Do you understand what you're charged with in the second-degree felony of manslaughter in 1745?
Yes, sir.
And in 1746, this alleges that that you intentionally or knowingly drove a vehicle that became involved in an accident resulting in the death of the victim. And knowing that that accident occurred, you intentionally or knowingly left the scene of that accident without giving your name, address, registration number, etc., and without rendering reasonable assistance to the victim when it was apparent that he was in need of medical treatment, and that is in violation of the other offense called accident involving death. Each of these are second-degree felonies, which mean if convicted, you face no less than no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range that was applicable in these cases?
Yes, sir.
Agreements have been reached where you would be pleading guilty. Is it the same agreement in each case?
No, Your Honor.
In 1745, an agreement has been reached. You would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. And there will be terms and conditions of probation, which
There's an agreement under the new law, you can order child support. They're agreeing to waive the ex post facto part of it, waive the right to not rely on that law, but we've agreed that he's going to pay child support till the child reaches 18. That's going to be determined by the time we do sentencing. We're asking for a pre-sentence report because we're going to use the family code to determine it.
was he the sole provider of the deceased was the sole provider of the child?
No, sir. That's why he's got, there's a mother and we just got
deceased live leave a mother to the child,
Yes,
a wife?
yes.
Okay. Is she here by any chance? You are, that is you,
Yeah,
ma'am?
family's here. They're present, and this has been all discussed with the family before we made this decision.
This is agreeable with y'all? Okay.
The agreement we discussed prior to.
On this, in this case, he was going to be pleading guilty. He would not be found guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. He would be fined $500. There would be terms and conditions of probation that this court can assess. And one of these is that the agreement that he is going to be ordered to pay child support in an amount to be determined by the court after the pre-sentence report is prepared. We're going to enter the plea, come back later and make sure that all the I's are dotted and T's are crossed and that everyone understands and is on board with the plan. Because this is changeable if necessary. And JCDI, okay, you have a substance abuse issue? No? Okay.
No,
All right.
that was a request of the family.
Okay. Well,
Yes, sir. I want to make sure.
so is this your understanding of the agreement on this case, 1745?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead in this case, charging you with the second-degree felony of manslaughter, guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir.
We're going to go to 1746. And again, does the defendant waive a formal reading of this indictment? Can we proceed in summary?
He does.
I think we discussed it, that you are alleged to have committed the second-degree felony of accident involving death. And in this case, you were facing a similar punishment range as the other, although third-degree felony is checked here. Can you
Should be
explain
second
that?
because of death. Should be second degree.
Okay, everybody right on that?
Yes, sir.
Because that's the way it's indicted.
Yes, sir.
The grand jury indicted
Yes, sir.
it as second-degree felony.
Yes, sir. It is second.
Okay, you're facing a second-degree felony here, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand that, sir?
Yes, sir.
An agreement has been reached. You would be pleading guilty in this case and sentenced to 3 years in prison. That would not be suspended. That would be flat prison time.
Yes, sir.
Is that your understanding of the agreement, which would run concurrently with the preceding case?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge of a second-degree felony of accident involving death, guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir.
I'm going to show you in each case what has been marked as State's Exhibit 1. Did you sign those documents? Understand them, discuss them with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence
Okay.
without objection. It is admitted. Among other things, this states you are mentally competent in each of these cases to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied by the representation by your lawyers. All of this is true. It states so help you God.
Yes, sir.
States Exhibit 1 is made a part of the record for all purposes. We're going to have a pre-sentence report.
Yes, sir.
We're going to hold this in suspense. Order of pre-sentence report will return back on
January 5th.
January 5th. Good for everybody?
Yes, sir.
If not, let me know when you know something differently. Each side
I'll check with
will have an
Pam.
opportunity to add information, and at that time, then we will allow family under the law to make any statements that they feel like they wish to make. But I urge, let's not make a decision until after the pre-sentence report is read, and then the state will get with the family and go over it so that y'all know where everything stands on the facts. But we want to make sure that it is accurate. The record is accurate as possible. And as well for the defense, the defendant has his constitutional rights and he has his opportunity to discuss this with his defense so that they can represent him fully and appropriately. Anything else to add at this time? If not, we are in recess on this case until January 5. Thank you. Please get a resetting.
New month here at the TCF bunker, but same goals, specifically 9 to 11% more Judge Boyd. So let's give that a go.
You're going to have to make sure you speak up because the court reporter wants to hear. All right, you entered into a plea on September 29th to counts 1, 2, and 3. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt as you applied for the deferred adjudication. According to your plea bargain agreement, there's a $500 fine to be probated. The counts are to run concurrently. There's to be $17,215.37 to be paid to Calton, C-A-L-T-O-N Investments, Inc. The defendant paid $5,000 prior to entering into the plea. And today the defendant paid $2,215.37. Is that correct?
That is correct, Your Honor.
Yes, Your Honor.
And the $7,215.37, is that towards the $17,000?
Yes, Your Honor. I think with that's not including the original 5,000, Judge, but the 2,215 is that gets us to an even 15,000.
Right. All right, is there anything you wish to say?
No, ma'am.
Again, you're whispering.
Sorry. No, ma'am.
All right, so why did you do this?
I was going through some stuff.
What were you going through?
Just financial stuff, and then I was having a lot of health issues at the time also.
Okay, let me ask you this. And I ask these questions because I want people to think about the actions they're taking, right?
Yes, ma'am.
So what if everybody who was going through some things and had some financial problems decided to steal?
It's not right, and I'm sorry.
Yeah. And because of what you've done, now you're going to have more financial difficulties. And the reason why you're going to have more financial difficulties is because now you're going to be on probation, which means my clients, they would always say, I want to get off of paper. What that means is you're going to be on paper under a contract with the court. The crime that you committed is a crime of moral turpitude. Your attorney will explain to you the impact that has on any type of career that you would be seeking. So anything that requires a license, this is going to negatively impact that. Are you currently employed?
Yes, ma'am.
What do you do?
I'm a leasing agent.
And are you handling money for them? And when you say you're a leasing agent, what do you do?
I make sure I gotta lease out the units, apartments.
Okay. And do you have any children?
Yes, I have one.
Age?
Oh, he's not little, he's 20.
Oh, he's 20. Do you have any grandchildren?
No.
That's a good thing. It's always nice when you have a 20-year-old and you don't have grandchildren yet, I guess. All right, probation. Counts 1, 2, and 3 is to run concurrently. There's to be regular reporting by Zoom or in person, regular random UAs. You can either do regular random UAs or the patch. The patch costs more. I think the patch is about $300. What happens with the patch is probation will put it on and you don't take it off. Probation will take it off. You can shower with it, but if you tamper with it, that's going to be a violation. The thing about the patch is that it frees up more time because you don't have to go to the office to do a drug test.
Oh, okay, so I just tell them which.
Yes. And they'll let you know. Who knows, the price may have gone down. They may have a program that can help pay for it.
Okay.
There's going to be field visits 1 time per month for 6 months. Proof of employment within 45 days. No employment as a home health care provider or with minors. There's to be restitution of $15,000 to Carlton, CARLTON Investments, Inc. Now, with regards to that $15,000 that is owed, how much are you able to pay towards that monthly?
Monthly, I would say about $350.
All right. All right. So she's to pay $300 per month. Towards the $15,000. There's to be no contact with the following. $1,400. Is this M or N?
Can I see it, Judge? North, 1400 North.
Okay. There's to be no contact with 1400 North Apartments. The Springwood Apartments. Trina, TRINA, Meyer, MEYER. Delia, DELIA, Broadnax, BROANDNAX. Maryland with 1 N, Meyer. And Brent Meyer. 5 years deferred adjudication. $500 fine, and that will be probated. And there's to be 100 hours of community service restitution. I'm going to require a money management course. Once you complete that, the community service hours will be deemed satisfied. Probation, is there anything else? Is there anything else you need from the court to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and
Yes, ma'am.
sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing in this court. In order to be successful on probation, communication is key. Do not disappear. Do not stop reporting for probation. If there's an issue, you need to let probation know about it. If you feel they're not addressing it, you can always come back and address it with me.
Okay.
You understand?
Yes, ma'am.
All right. Probation will go over conditions with you. Make sure that you pay that $300 per month, okay?
Yes, ma'am.
All right, good luck.
Thank you.
I do have one thing.
Yes.
One, actually, two things. The first one, my fault, not yours. It's not Carlton, it's Calton. I just want to make sure for probation purposes.
All right.
CAL. And then the second, CALTON.
All right. Probation, that will be Calton Investments. Yes.
And then the second thing, my complainant in this case, she did prepare a letter that she would like to read to the defendant. However, you would like that to take place.
Oh, do you want to give her the letter or you want to read it?
I think she would like to read it, Your Honor.
Oh, she's here?
Yes, Your Honor.
Oh, yes, she may proceed.
Be here, ma'am.
What ends up happening now is the complainant is, they usually tell you how this has impacted their life. So listen and internalize, all right? Thank you.
Be here, ma'am. You're back against the cover.
Unfortunately, Judge Boyd never lets us in on those things. That'd be good to hear, but we won't get that. Michael said in the chat that the money management course was kind of a new thing. I agree. Makes sense. Obviously, she can't manage her money or she wouldn't need to thieve it. And she's got a lot to pay back, so hopefully she gets things sorted. Let's go to Lake County, Ohio. We'll say good morning to Judge Collada. He was grumpy last week. Let's see how it's going today.
Before you this morning is case number 2010 CR 164, captioned State of Ohio versus Michael C. Zajac. Judge, we are here today as a result of a motion that was filed on September 10th of 2025, asking that the defendant's prior conviction for burglary be sealed. The defendant filed the motion. The state responded on September 30th of 2025, and the matter was set for hearing today.
Thank you. Mr. Bonder, do you care to be heard on your request, your motion?
I do, Your Honor. May it please the court. I don't want to reiterate a lot of the things that have pretty much been stipulated or admitted to, but as the court knows, being the judge at the both the plea and the sentencing phase of this matter, the defendant pled through an Alford plea back in June 2010 to the 4th-degree burglary. Court was put him on the 2 years of community control, which he satisfied and was discharged from that community control back in 2012. There was a filing back in 2019, and the court ruled that it wasn't, the court denied the motion back in 2020. And I believe by reviewing all the information that's in front of me, including both the state's reply and our motion, that the defendant's been admitted, the defendant's eligible for this type of relief. There have been no criminal proceedings pending against him since his prior application back in 2019 and through the court's ruling in 2020. In fact, the information that's cited by the state in this particular matter indicates that he shows a disregard for the law through some traffic violations, and specifically cites an October 2020 speeding conviction in Massillon Municipal Court, and then a June 2025 speeding conviction in Medina. It doesn't indicate what the other traffic offenses are for, but I'm assuming they're not as quote-unquote serious as those two, and the continued disregard apparently involves him traveling in excess of 20 miles an hour over the speed limit. But as it relates to criminal proceedings, nothing pending since the last application and the court's ruling. We do feel that the defendant's been rehabilitated, Your Honor. He's 40 years old now. This incident occurred back when he was 23. And as I've indicated, there's been no evidence of any type of behavior since his last application that's indicative of any kind of criminal cases. He does have an interest in having his record sealed, and I believe it overrides the government's interest. This is a burglary conviction. I know there's a lot of weight being thrown at the charge that was dismissed, but knowing you and knowing your background and you knowing my background, we both know that if there was anything egregious, and I say this with all due respect to that particular case, I'm not here to downplay the severity of it, that the court may not have been inclined to give him the community control it did back then. But in any event, I believe he's being punished to a certain degree, and most of it is his fault. But as it relates to this particular application, due to some of the circumstances involving a case that has since been dismissed, and I think we both know that if it was as egregious as the state's making it appear, that certainly the state would have proceeded trying to get a conviction in that particular matter as opposed to the burglary. So we're left with this F4 burglary charge, which I believe is ripe for a ceiling at this point in time, Your Honor. As I indicated, he's 40 years old. He was gainfully employed at Davy Tree until the seasonal process hit, and now he's working through a company called Nesco doing some warehousing work. He suffered a work injury but is about to get back on the job. But just as importantly, no indications of any ongoing criminal behavior since the original application was denied in 2020, Your Honor. Thank you.
Thank you.
You're welcome.
Mr. Zajac, do you care to be heard on your request? You don't have to, but I want to make sure you're given an opportunity to speak if you'd like to.
Yes, Your Honor. I feel like I'm a more mature and just well-rounded individual since then. And
what are you doing now?
Now I'm currently getting back to work. I was working in a warehouse. I got injured on the job, so I got cleared actually today to go back to work today.
What kind of work?
I was working for Dealer Tire and warehouse, tire warehouse place.
What's the, I'm just reading your lawyer's motion here. There's something about HVAC school.
Oh, yeah.
What's that about?
Yeah, I went to HVAC school back in 2012. I completed it.
Down in Columbus?
No, I'm out of Polaris in Middleburg.
Oh, I thought Polaris. I thought it was Columbus. I'm sorry.
Today.
You do anything with that certificate or?
Yeah, I did do a few. I worked for a couple companies. It's not the type of career that I thought it would be. So.
Okay. Where are you living now?
I live at home with my mother.
Which is where? I forget.
Oh, it's in North Royalton.
Anything else you'd like to say?
No, that's about it.
All right. Thank you. You may be seated.
Thank you.
Mr. Bond, anything else on your request?
No, Your Honor. Thank you very much.
Mr. Road for the state.
Judge, I won't reiterate the arguments previously advanced in the state's brief, but I would simply stand on the section of the brief where it says that the court's findings regarding the facts and circumstances of his felony conviction at issue remain true today. And in addition to those subsequent convictions, and he's still displaying an ongoing pattern of illegal behavior, and it certainly is suggestive for the fact that the state needs to maintain those records for his conviction, and that outweighs his need to have the records.
Because of the speeding convictions? That's necessary to maintain the records because of the speeding convictions?
Well, as I understand that.
I've never heard that argument. I never heard us refer to traffic records before in the expungement hearing.
First time I've argued that it be advanced, Judge. They were speeding convictions. They were in excess of 20 miles an hour. A little weightier than the standard ones. I assume he had to appear in court. But with respect to that, the specific facts and circumstances regarding his felony conviction, Judge, that were advanced in the previous objection and addressed by the court back in 2020 remain.
Dan, is there something wrong with the imaging, do you know?
I don't think so, sir. No, I was looking earlier.
No.
For what it's worth, Judge, I couldn't get on the clerks this morning.
All right, well, I'm going to take this matter under advisement and issue a ruling here in the next, within the next week.
Thank you, Judge. Appreciate it.
All right.
Okie dokie. No satisfaction there. No idea how that's going to end. We'll probably get satisfaction here. We have so far this morning. Let's go to back to Judge Stevens.
Yes, sir. All right. In 25 CR 53 here, this indictment, as you probably know, you have been indicted for the 3rd-degree felony of evading arrest or detention with a motor vehicle. And this occurred, it states in the indictment, on or about November 6, 2024. That's a 3rd-degree felony, which carries with it, if convicted, no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're facing?
Yes, sir.
It doesn't end there. You have a rich criminal history. So in 2002, the state you were convicted of robbery out of Harris County and sentenced. Thereafter, that robbery was final. It is alleged you committed burglary of a habitation and were convicted of that in 2008 in Harris County, Texas. That right there, those two, robbery and burglary, place you in a situation where you are looking at habitual felon status. But looks like you have 2 other convictions after that. In 2016, you were convicted of evading arrest or detention with a motor, evading arrest or detention with a motor vehicle, which is interesting. It's the same type of crime you were charged with in this case. And also indecency with a child, you were convicted also on that same day. And those were out of district courts in Harris County. So you were a habitual felon 2 convictions ago. And here you are. So you're looking at no less than 25 years in prison to life in prison. Do you understand the punishment range that you face because of all of this? So with all that, he understands. What do we do?
Judge, he has expressed to me that his wife will be hiring him and a different attorney by the end of this week. Isn't that what you told me? Okay, soon. She will be hiring a different attorney soon. Yes. Mr. Hand has extended an offer. We had discussions and that offer started at 25, which was the minimum of that habitual status range that he was looking at. Through discussions, Mr. Ham has agreed to abandon those enhancements and just give him 10, which was within the punishment range for a 3rd-degree felony. We've talked about those offers. He knows what that looks like, and I've explained that to him, but in our discussion today, he has expressed that he wishes to hire another attorney.
Yeah. Okay, so he signs an affidavit of indigence over a year ago. And one of the justice of the peace here. It's
Which is usually done intake.
no, I know. That's not the point is then only see 2 resettings in November and December after he was appointed. He for a year, nothing happens for 1 year on this on Urbana. What happened? I don't. There are no resettings except it jumps up to November.
Judge, he was bench warranted here from TDC. So I'm not sure what that process looks like in terms of.
See,
He was sent.
he was indicted over, going on a year here.
Yes.
And
Judge, he was arrested here, he was sent, it's just released to another agency. So someone came and got him after he was only here for about 8 days back in November.
where'd you go?
24.
You know,
Montgomery County Circuit.
Montgomery.
And then they sent him to TDC, I believe. And then he came here from TDC.
All right. Well, what we're gonna Here. What we're going to do is, he can get another lawyer, but I'm putting it on the trial docket. We're just going to default it over to the trial docket. No deal. Don't want a deal. I'm not going to get one. Let's try this case as soon as somebody can handle it. And if you hire somebody, that's great. Otherwise, we're going to move forward to trial. You understand? I'm not going to wait. It's been too long. We're just waiting around. And that's not the way we do things. We move forward.
I've advised his current lawyer that the offer that I extended is
Revoked.
It's withdrawn.
Okay, so there is no deal now. We're just going to go to trial. We'll set it for trial, and if you can get somebody, fine, but they got to be ready to go to trial. I'm not going to wait around. You've had a year to get ready.
I was in custody.
Yeah, so what? You go and get a lawyer if you need to, but now you're asking for a lawyer. You're still in custody. Now you want more time. You've had a year. It's time to move forward. We move forward. We go forward, not lollygag. Okay? Set for trial. Set for trial. Set. All right. Crystal Vaughn. Bruce. There, hello. Yeah. Okay, what are we gonna do? What are we gonna do?
Dr. Pond,
I know.
says that she's competent
She's
and I have had all kinds of problems, but I talked to her this morning and she wants a hearing on this motion.
Okay, when can we be ready?
It's only about non-reporting, Judge, so
Come on out.
they can actually do it now if they want to.
Judge, I would ask that I have serious concerns. Every time I've gone to the jail, this woman that they report to me.
Are you Crystal Vaughn?
Yes, sir.
Okay, you understand Mr. Smith is your attorney?
Yes, sir.
Okay. You also understand there's a motion to revoke unadjudicated probation that's pending? Yeah, I'm talking to you.
No, sir.
You were on, you
No.
don't remember being placed on probation?
Yes, sir, I do.
Okay, then back in July, the state filed this motion. Have you had a chance to review it?
No, sir, I have not.
Judge, I went out for the first time, I went over with her this morning.
This morning?
In the room.
Oh, you don't remember doing that?
I wasn't in the jury room, sir, going over this.
Ma'am,
I wasn't in the jury room going
where
over
were you?
this. I was at the other unit, at the stalls unit, PA dorm.
You understand, but you understand there's a motion to revoke probation that's been filed against. You said you went over it.
No, sir, I did not go over it because I was not told that a logger was at, I guess, where were you? At the main ward?
All right.
I was in
Let me
KA
help you.
dorm. I did not realize it.
Just
Let me-
I was there to tell
That's the fail right there.
I understand, but
It's not
look,
fair.
Dr. Grapon has analyzed her and deems her to be competent. And
The problem that I have with Dr. Pond report is that he had previously examined her a year ago and reported that at that time she had been previously diagnosed with dissociative identity disorder. And she had also been diagnosed with personality disorder when he did his examination on November the 4th. With my client, she reported that she had no prior problems with any kind of mental health problems, which directly contradicts Dr. Papon's report. I have been out.
that's not, no, that doesn't contradict. It says, his report says she states.
I get
And then
she thinks
that. Well, that's not what he concluded. I mean, but he concluded that she was deemed competent. So that's what's accurate.
Yeah.
Okay.
But if we're going to have a hearing, then I'm going to want to subpoena some officers from the jail.
Okay. When can you do that?
Well, I'm fixed to have surgery, and as we well knows.
I don't really know much about, I know people, I had appendicitis once.
Yeah.
That's about it.
I'm having 12 inches for my colon.
How long is that going to?
Well, I'm in pre-op all this week. The surgery is Monday.
And then what's?
They say I'll be out at least 3 weeks then.
We may purchase some more guys.
We, Crystal, well, we might not be able to get to this for about a month. Is that okay with you? Or do you want to move this quicker?
And where would I stay in the meantime?
You're gonna head bit in the jail.
Huh?
In the jail.
At KA Dorm, the where
Yeah,
previously.
so, yes, ma'am.
Yes, that's fine, sir. I would like to say
Okay.
though in my defense that I did report this to Mr. Anton at Bridge City, Police Department, where my car was vandalized and I was unable to report to parole. So I reported vandalism of my vehicle to Mr. Anton.
It's not parole, it was the probation officer.
Well, the probation officer, sir, but I was unable to make it. I couldn't walk from Bridge City to Beaumont or wherever it was since I've never been in trouble before. But I did report it. I also reported a break into my house at the same time where the keys were stolen from my Audi at the same time. It was reported I was reported to Mr. Anton. He actually wrote it in a little notebook, refused to do a report. However, after that, the people at the water department, you could actually call them as a witness. They knew. I actually approached them first about it. So they were witnesses, sir.
Judge, I just want you to note that the accusation.
Time she reported. When was she?
She's never reported is reason what I was trying to bring to your attention, Judge.
All right, everybody's talking at once.
What's about
She's placed in probation in May.
And you don't report. Hold on. I had two people and now you piped in as a third.
Well,
This is a chorus. It's not a chorus. It's, solos. All right, first of all, Bruce.
She was placed on probation in May this year.
Okay.
The allegation is that she never reported to the
When was she
probation
put in jail? When was she placed in jail? Does anybody know? Jeannie, do you know when she was?
She was released from custody on May 28th of 2025. And she was placed on probation, obviously the same day, but.
No, when did she end up going back to jail?
When on the warrant.
This is fifth, I believe.
Mr. Menard made contact with her, in Jefferson County Jail on August the 15th of 2025.
Do you remember when you were arrested by any chance? Do you remember the day you were arrested on this?
I believe she was arrested.
After you were put on probation?
Your Honor, she was arrested August 12th.
Okay, hold on. So August 11th is what we're showing on the records. So she appears here on May 28th. She's placed on probation on May 28th. Then we've got June 28th, July 28th, 2 months and a couple of weeks.
Yeah, there.
Okay. And she was to appear how often?
Your Honor, she was to appear at the probation office immediately upon her release or the following business day.
The next day. And, okay, so according to this, the findings here on this administrative hearing, the defendant was released from jail on May 28th at 7:05 p.m., failed to report to the probation office the next day as required. That would have been May 29th and has not made any contact with the office. So that's what prompted this is we go a little over 2 months and no reporting. I mean, when you're on probation, the first thing you have to do is report and you just can't do it on your own,
My car broke down. An officer gave me a ride. From there, I reported.
No, wait, did you called? Who did you call with the
I tried to
probation?
call.
No, who did you
I
contact?
don't remember. It was on the paper. I don't have.
Do y'all have any,
No. I called.
I'm talking about.
No one answered. No one
Yeah,
answered. So I called and I went over to
What time were you
the
calling
water
during the
department.
business day?
No, it was later in the
At night, at
evening.
midnight?
Yeah, and then I called in
You
the
called at
morning and then I
midnight?
went over to the water department because I was.
How about during the
they-
day? Did you call during the business day?
Yes,
When?
I think it was.
Let me just tell you, I've never had a problem in
7:48.
20 years. I contact them, somebody always answers during the business day.
Okay.
So. Well.
It could have been a reroute on the phone. I don't know.
You think so?
Well, landline.
Yes. Well, generally that doesn't happen, and we've got to kind of figure out what's reasonable, with this.
Well,
But in
reach the
probation,
officer.
you have an obligation that you can, instead of going to prison, we gave you a chance to work through this during probation. And the foremost responsibility you have is to report. You have to do that. Everybody has to do that. If you don't, you're not on probation. It's just the way it is. Simple. So you have an obligation, like all the probation officers have. You've got to figure it out. And the phones were, come on, we have to see you in person, and that's vital and necessary. But here you're flirting with 10 years in prison. Why would you do that?
For parole violation?
Evading arrest, or just you're on my probation for evading arrest, or do you not remember it? Good,
Evading
good.
arrest, but
We
also
went over
to-
this. We went over this so delicately and deliberately. You know, you're looking at 10 years in prison if you fail on this.
Okay.
One failure is something you could be revoked for. We hadn't seen you in months. You're supposed to be appearing regularly, or you're not on probation. That's the first thing. You got to show up. I don't know how you feel like you can't otherwise do that.
A vandalism to the car recording.
You got to call. We have every business day, they answer the phone. Come on. I've never had a problem in 20 years. You're not going to be any different. The very first thing here, you've got obligations, and you've got 35 conditions here. But the most important is to regularly report so that they're supervising you. If you can't do that, then you can't be supervised, which means thus you can't be on probation. And there's only one other option, and it's up to 10 years in prison. Have you ever been to prison before?
No, sir.
Good. You don't want to be. You don't want to go. You don't want to.
No, I'd like to see my grandchildren. I really.
Well, they come in. They come in handy as wonderful parts of life. But this is a responsibility that you have that can get in the way of all of that. And I mean, if you do it here, you wouldn't be parolable until 2.5 years were served. That's a long time not to see the kids. Anyway, what's everybody want to do right now? I know
my argument is that I truly believe, with talking to everybody that I have talked to her this morning and there, I truly believe that my client has been ill. And this is
Dr. Grapan decides otherwise. Sorry, she can say whatever she wants out of her mouth until you can be the psychiatrist. All you can do is respond to what she's telling you, and the doctor knows better. And we're just going to. You've been doing this longer than I have, Bruce, and you know sometimes they're not forthright with you. Often your clients aren't. That's the way they were with me. Yeah, we all have. It's the way things are. The question is until Dr. Grapan deems otherwise, she is presumed competent.
You asked the question, what should we do? My answer is,
what do you want?
In my opinion, her failure to report is totally due to her mental problem that I feel that she needs to be reinstated on probation in a mental health type of so that she can receive the kind of help that she needs, because she is going to have that constant.
What's probation office?
Your Honor.
What did y'all think about it?
All I can base my, any statement on is what Mr. Menard had stated, when he made contact with her August 15th of 25 at the jail. And he also noted, a mental health,
concern.
Well, what should we do?
Other than that, we have no information on her because of the fact she had failed to report. We don't know where she resides. Sounds like she resides in Orange County. We can submit.
Is that where you live?
Orange County.
Is that where you live now?
I live in, yes, I live in the historic district in Orange,
Okay.
in the city of Orange.
All right. Because if I release you on this probation,
Yes,
you've got to follow. You know, we're making a big deal about this. This is important. The foremost thing you have to do is report. Foremost, it all flows from there. Failure is not an option for you. You go to prison. Do you understand? That's
Yes.
where you would head up to 10 years. And the court, you have to report. If you don't report, you're not in the game. And you got to be in the game. So that's the very first thing you have to do is report as directed by the probation office. We're going to also, when you're going to be released, I'm going to release you. And the first thing you do is you go to the probation office if it's during the work day. Do you understand that? It is the first work day you're able to report when you are released. You go to them. If you don't, I will order a warrant and I'll say, we talked about this and shame on you. You know what you have to do. You follow their directions as well. Do you understand? You have to
Yes.
speak out. Do you understand that?
yes.
So that there's not any confusion.
Okay, I don't have a vehicle as of this time. It's still messed up. It's in the front. Of
Where do you live? In Orange, you said?
Yes, I live in Orange.
Okay, how do you
So
live?
it's in Bridge City. I stay in Bridge City some. It's across the street from the water department.
Does somebody have a vehicle that helps you move from one place to another? Do you have children or anything?
Yes, sir, but
But
out
no
of
thing.
state, I
But-
was going packing my bags. to go out
Ma'am,
of
but
state.
is not an option. You've got to report. How are you going to do that?
I don't know without a vehicle, sir. That's what I
You will
was
see
trying
a
to
lot
get
of people
fixed.
who don't have vehicles, they still are obligated to report. Yes, Jeannie?
Your Honor, and what, the defendant is speaking of, is one, Orange, if we try to submit her case for courtesy supervision to Orange County does not offer a mental health caseload. However, they do have spinal tap services, available in Orange County. But if her, inability to even advise the court of where she resides, she can't reside in Bridge City and Orange. She has to reside in one location. Orange County will not accept that without one location being reside. And now she's just speaking of going out of state. We don't just go out of state.
No, that was prior to. Prior to.
That's not what she just said, Your Honor.
I don't know.
I caught the same thing.
I know.
It's in,
The more you speak, the closer you get to prison. I've got to be able to trust you to release you. Can I? I'm asking you. Can I trust you?
Yes,
To
sir.
follow the, all right. You're gonna
Okay.
have.
Yes, sir, but I don't have a
You're gonna-
vehicle, so from
All right.
where I'm just being honest. So you release me, do you release me from here? I don't know. I've never been in trouble before, so I don't know. So it's not being confrontational. I just,
Yeah. We're trying to work with you here and you're kind of pushing back. You either are able to report or not. If you can't report, that's a problem. You have to be able to report, but you're on probation. You got to figure it out. Everybody does. We have 5,000 probationers.
the practical stuff, yes.
the question I've got is what happened with that Orange County? If she's under their supervision from that offense, it might assist us in resolving.
Bruce, on your, what did you figure? What'd
He's not here.
you figure out on that other case that was pending in Orange County? Do you know what happened on that? You're charged with evading arrest or detention with a vehicle out of Orange County. Do you know what happened on that case?
Detention of a vehicle.
Yes, I just spoke.
I'm not aware of Orange County having.
Evading arrest or detention with a motor vehicle.
Charged before and I was released and it was to probation. And failure to appear, I guess, for probation is a charge, correct?
No, I think he was phone calling to find out for that.
I think
Here's what
we
we're gonna
And,
do is we're
I
gonna figure
report
this
to the
out. I'm gonna
vehicle.
reset this for a week. Okay, I'm gonna reset this. And there's a lot of gaps that aren't being filled out.
I have a problem with Orange County as well.
Ms. Vaughn, you
The last time I checked,
try
it
to
has been it died.
give us information that is helpful or not, but you're acting like you don't even know anything about yourself. And we'll figure it out.
I
But
do
it's gonna
know about
take a
this.
while.
I
And you
reported the
can't help
victims of
it,
the
you can't help but
vehicle.
interrupt people, can you? That's even rude. We learned that first. We'll see you back in 1 week. Thank you. All right, did you have anything else, Bruce? Bruce, did you have anything?
The only thing I have to do is on the trial, I was Aaron, Tyler, and I filed that both with continuing student and search.
All right, done. You got it.
Yes.
Hey, Brent, Donald Barnes.
Yeah, that was Paul. Oh, yeah, I'm gonna be representing him. They go on to that.
Who?
On the-
Hey, let me see his two cases. He's on phone.
I actually represented him on the weekends. With probation.
We have a motion to revoke probation.
While we wait for the contestant to come up, I'm going to go ahead and stick with Judge Stevens for a while because I agree with everybody in chat. He's been overly entertaining today. So we'll continue to run with that. Again, happy Monday to you. Happy December. Thanks for joining us here at the Courtroom Files Live. Appreciate all of you. Let's have a good month. November was weird. Let's make December something to remember. Isn't that like the Lexus sales event, the December to remember? That sounds about right. Anywho, back to Judge.
A drug case as the defendant was placed on 10 years probation in June, and it is alleged that he committed the offense of illegal possession of a controlled substance. I don't even know what that is, though. It's not listed here. Sure. We may need to amend this. And then associated with a disreputable person. All right. And then we've got a pending. I'm sorry. After that, the defendant is indicted for an event that happened in August of 2024.
So that actually predates, the offense predates his probation in that new matter, and how we dispose of that is going to turn on what we're doing with the probation. The new offense is alleged there.
Well, the motions always go first.
Right.
So you're going to come in on this,
Yes.
and then when can we be ready for a hearing on this?
Which is on the new law violation on the motion. I know I've talked to Mr. Ham, who was trying to check into that, what was going on. I don't know how much time.
We need about 30 days, Judge, so I need to track down what's going on, why we haven't received that offense yet.
4 weeks. All right, reset 4 weeks for the hearing.
Hearing.
Thank you. And that's on that MTRP.
Yeah. Yes, sir.
That's pending. Okay, Ashley McKinney.
Judge, if we have this more stuff on the trial docket for a fee, do she in the queue somewhere?
Yeah.
Okay. She's in Miss McKinney's in the package. So.
Talking about Carson Moore.
Sir, she's gonna be a less.
Carson.
Or should we do that first or?
Yeah.
Okay,
Okay, I need, more to come fingerprint. Yeah. Raise your right hand. Yes, right. All kinds of stuff. This is stuff you got, or yours. Okay, you have your right hand first. Place it flat right down the box. You get up one more time. Close it flat right there.
You
Good. Stand in front of judge.
She's doing what Jamie.
This is Nora.
25 CR 40. 25 CR 497 is now called the State of Texas versus Carson Moore. Is that you?
Yes, sir.
Present with your attorney, Mr. Turpin, the state's attorney. Does the defendant with a formal reading of this indictment and arraignment, can we proceed in silence?
You have a, she does.
In summary, this indictment alleges that on or about February 14th, 2025 in Jefferson County, Texas, you committed a second-degree felony of assault on a peace officer. Do you understand what you're charged with here?
Judge, let's make sure we're clear. This is going to be a lesser included of assault.
Do you understand what you're charged with in the indictment?
Yes, sir.
All right. That would be a second-degree felony. You have an agreement that I'm looking at that states you would be pleading guilty to the lesser Class A misdemeanor of assault, which carries with it up to 1 year in the county jail and/or a fine up to $4,000. Is that your understanding?
Yes.
You're looking over at him. But you understand the punishment range and what the plan is.
Yes, sir.
Okay. An agreement has further been reached. You would be pleading guilty to this Class A misdemeanor and placed on 2 years deferred of unadjudicated probation. Correct?
Yes, sir.
So if I follow this agreement, you have no right of appeal. You understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily?
Yes, sir.
That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. The states you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your right to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. And you're totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report, right?
Yes, Judge.
Multitasking here and writing on the indictment. He has pleaded guilty to, which is the lesser included Class A misdemeanor. All right, I'm going to follow this agreement and find you are mentally competent to enter this guilty plea to this lesser included Class A misdemeanor of assault. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this lesser included Class A misdemeanor of assault. However, I'm going to instead defer any finding of guilt and place you on deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation for this misdemeanor assault, not the least of which is you shall complete an anger management program. That's the right, which helps you make cool choice decisions when you're under pressure, which I think is behind all of this. and other terms and conditions of probation. Make sure you follow them. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 1 year in the county jail. Okay. You understand what's happening? They see the probation office.
Barbara shouting out our jewelry business, Art and Soul, in the chat. Thank you so much for your kind words regarding that. Again, we don't normally mix our businesses here at the TCF Bunker, but it's Christmas, so let's let you know some of the other things that we do. And it's all very giftable stuff. artandsoul.etsy.com. There is a link in the chat. Feel free to check that out. If you buy today, Etsy's throwing an additional discount on top of our sales, so it's definitely worth looking at. Let's change it up, 9 to 11% more Judge Boyd. Let's go back there.
This number came up wrong. All right, so this case was dismissed for pretrial diversion. Then I guess something happened and it was re-indicted.
Has it been reindicted or it was reindicted? Okay.
Yes.
Your Honor, Mr. Flannery and I have discussed the situation and he's provided me some medical documentation related to Mr. Martinez. So with that in mind, we're actually approving him to get back into the program and finish it out. And that's what Mr. Flannery and me.
That's correct, Judge.
All right, so this is what I'm telling everybody with this PTD contract. We're not going to do this a third time where it's dismissed, then it comes back. What will end up happening? This is PTD. That's your contract. If there's a violation of it and it's determined that you violated whatever agreement you have with the state, I'm not going to sign off or accept any PTD. The next setting that you have will be your trial date. So, for example, you're here today. If this were a day where you violated PTD again, this will be your trial date. So you all need to have your discovery and everything taken care of, because if there's a violation of the PTD, then you'll be up for jury trial. All right, Ms. Ferguson, a PTD date?
She put that, Judge. I'm sorry, Judge. She put that on this counseling stuff for her.
And just for the record, he has a medical condition known as psoriasis, which interfered with his ability to urinate. And that's why on one of the occasions.
Well, I mean, that's something the state should know. And
Well, they know, that's why I told him.
no.
And that's why he's back on.
I mean, my thing is that's something that should have been done before we get to the point where a PTD is dismissed and then it comes back and it's re-indicted.
I agree. And we had tremendous I had problems reaching out to the pretrial service office because, you know, we sent them the records to show them all this stuff. They terminated him without, you know.
All right.
In spite of the medical conditions, they terminated him. It's not the DA that's office fault. It's
All right, this is coming back on January 5th.
January 5th?
Yes, once you sign the reset form, you'll be excused.
Thanks, Judge.
Thank you. Thank you for addressing appropriately for court.
Thanks, Judge.
You're welcome. And that's PTD.
Yes, sir.
Okie dokie, friends. Let's continue to play the Texas ping pong. Back to Judge Stevens, new contestant.
Probation office is here. You are on probation in clause number 25, CR 292, Class A misdemeanor, lesser included Class A misdemeanor of theft. And there's a motion to revoke probation that's been filed alleging 7 different violations, not the least of which committing the new offense of theft of property, providing urine samples showing marijuana and methamphetamine in your system, failing to work faithfully, failing to successfully complete the substance abuse assessment, failing to report properly to Tyler County that we allowed you. I guess that was a foolish thought on my part. That was a waste of my effort. And failing to report to Jefferson County. That is all under this motion to revoke probation. And you are looking at up to 1 year in jail based upon the disposition of that, which we'll do first. Then you've got a new indictment in 25 CR 1293, which alleges that you committed the 2nd-degree felony of illegal possession of methamphetamine. But it also alleges you have a prior conviction next door out of the 252nd District Court for illegal possession of a controlled substance in 2022. And so if all of that was proven true, you're looking at 1st-degree felony punishment. You're looking at up to life imprisonment. So that's where we are. Now, the first thing we'll do is get the motion to revoke done. And then I'll just, I guess, set this for trial on the other. And is that what we want to do? All right. Then that shall be done that way. I don't hear anything. You don't have time to talk about this. That's what we'll do. We can just, y'all get ready for this motion to revoke. Y'all horsing around. Come on.
We'll get it done, Judge.
It's going to be the way it's going to be done. Y'all have a chance to fix this and figure it out. Don't do it here on the. Marcus Miles was reset. Then I have Edward Atremba. Yeah.
Yeah.
That's Jim. Say Jim's was supposed to be. That was a lifetime ago. Who told me first?
That just went a little weird. So.
And that's for a.
All right, while we wait for the next contestant there, we'll go back to Judge Boyd.
Yes, John.
Hello. How are you doing?
I'm doing very well.
Okay. So what is the update on his evaluation, counsel?
He was found competent to stand trial, even though he does have some mental conditions.
And has that been heard by magistrate's court?
Yes, ma'am.
So what are you all doing with this case?
I received an offer today. I'd like more time to confer with my client on this. I'm not sure he's grasping everything that I'm telling him. And I think I'm going to need an investigator in this case. I'll be filing a motion for an investigator.
All right, this being set for December 11th for a plea deadline date.
I was trying to confess that me and my homeboy.
No. Don't say it, okay? I'll talk to you again.
All right. Thank you. Yes.
You think the Joe, what's that program, Early Morning, Joe Scarborough?
No, I haven't had a
He's
chance
not
to-
happy. He's not happy with.
Oh, no.
Same issues.
Yeah, not happy.
Be braille about it.
Mm-hmm. Yeah, who's next?
I don't think anybody else.
Okay.
Ping pong continues. Back to Judge Stevens.
In this court, going on 10 years ago. It'll be 10 years ago. And you on February 8th of 2016. And failed to report according to this motion to revoke probation in June of 2016. You were required to meet with the probation office upon release, and I guess that never happened. He was released from custody, and then almost a decade goes by. You have to figure out that we did something up here for probation for some purpose. Because I signed this order placing you on 5 years probation on February 8th of 2016. So it's alleged you never reported, I guess, ever. And then they filed this motion in August of 2016 and finally stumbled upon you a decade later. And here you are now.
Yes, sir.
And Mr. Turk is your attorney. This motion is pending. And what we'll do is hear this thing as soon as y'all can be ready.
Okay.
Well, can you be ready?
Next week?
Yeah, let's do it next week.
This is easy, Judge.
Okay, we'll set that for next week, and thank you. Gregory Woods. Gregory Woods is next. Thanks. You're doing a fine job.
This is very exciting.
That was just smooth, complete. It was the smooth working of the door.
Very exciting.
Used to be my job, you know.
I just. Yeah. So. Yeah. Information. Yeah. I know. No.
Hold the ruckus down. I can't hear up here. What are y'all watching? A ball game? Oh, the tree lighting? We're up here.
Yeah.
We're up here. Everything's going on there. Okay, you're Gregory Woods.
Yes, sir.
All right, you were here with Mr. Turk, your attorney, and the state's attorney is present. Earlier, you pleaded guilty to credit or debit card abuse involving an elderly victim. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it?
Stuff was in the defense judge.
Judge, there was a letter that's on the last page that appears to be from a different defendant. If you look at the name on the back, that's not this defendant. Okay, it's on the back of.
You mean this one's purporting to be Colton Armstrong?
Yes, sir. That's not this defendant.
I didn't get a copy of that, so I was unaware of it.
Yeah, we can get this back to the probation office and it must go to another defendant, and it says it's written to Judge West. Otherwise,
As far as I know, we're good.
So.
Yeah.
There's probably any type of theft-related offense that's any worse than victimizing an elderly person, right? Would you agree? That's what you're honest with, though.
Yeah.
That's what you got to. This person is 77 years of age, which dropped a bag that he carries that contains debit and credit cards, personal belongings, and a Ruger Magnum 5-shot revolver. This occurred at Lowe's Home Improvement. And as soon as he discovered that, he canceled his cards. His Third Coast credit card was not canceled, and he began getting notifications from Third Coast Bank that purchases were being improperly made. I guess that's what you were up to. And it showed it all traced back to you. And a video also was recovered showing you making the transactions that victimized this person. And let's see. I left out of Walmart. There was a Lowe's parking lot. I found a backpack. I looked around and kept it. That's what you said. You did more than that. You misused the credit cards, right?
No, I was looking to see if somebody was there.
Somebody lost the credit card. That was you, right? That was using it? Sir? Well, you knew that was wrong. Wasn't that, you knew that wasn't you. They don't give free money away. You know that. Says $4,000 was somehow taken from the plaintiff. Looks like you somehow acquired $300 to $400 in cash. I don't know where's the rest of that loss came from. So his cell phone and other credit cards and the handgun were never recovered. According to the district attorney's office, $1,531.68 is requested in restitution. $1,531.68 should be paid to Third Coast Credit, and $2,468.32 paid to him. That totals $4,000. So what are we going to do?
Judge, Mr. Woods would like to receive probation in this, and what he's asking the court to do is, as the court noted earlier, one of the worst things you can do is doing with an elderly person. But Mr. Woods, at that time, when he made the poor decision to take it back, he did not know the age of the owner. He did make a bad decision in using the credit cards and contents of the bag, but he did not know the age of the person that owned it. I don't think he probably knew it until probably he got arrested for it. He has also had a pretty serious car wreck earlier this year, which requires, from what I gather, some extensive prescription regimen. And he's waiting for benefits from Social Security and whatnot. He can only stand for 30 minutes, as noted in the PSI. He can't lift a whole lot of weight, so he's got some disability issues. He was in a coma apparently for 3 weeks. His criminal history, while pretty long, he hasn't had anything really of felony within the last 10 years. What Mr. Woods told me his last time felony was, he actually said he owned up to what he did and he wanted to take the time instead of drug treatment. So he voluntarily went into his last one. So in 2014, that was the explanation of that particular felony. And it's been about 10 years since that happened anyway. And since then, I think there's been some notes on some misdemeanor issues, but for the most part, he's been doing what he's supposed to do. He made a terrible mistake in keeping the bag in Lowe's. There's no excuse for that, but that's why he's owned up to this and he's accepted he's pled guilty, Judge, but he would really like to be put on probation so that he can make the restitution payments to the bank.
How's he going to do that?
I think he's going to get disability from Social Security.
Oh. Let me ask you this. Out of all your convictions, when did you ever pay anybody back? Ever.
Yeah.
How many, let's start, how many convictions do you have? Let's see if you can guess correctly. It's your life.
Like 4,
sir?
like 4 or 5 probably.
Is that your final answer, 4 or 5? Okay, let's count these. Let's see. We've got misdemeanors, willful obstruction. I don't even understand what this means. LEO. Law enforcement of a law enforcement officer, I guess, out of Newton County, Georgia. 12 months probation in 2008. criminal trespass, also 12 months probation in OA there in Georgia. Resisting an officer, 28 days in jail. 19, resisting an officer, 28 days in jail in second case out of St. Charles Parish. Class B theft in 24, 9 days in jail. Evading arrest or detention in December 24, 24 days in jail. Failure to identify in 25, 30 days in jail. So what is that? What is that? 1, 2, 3, 4, 5, 6. That's 7. Let's go to the felonies. Burglary out of Lafourche Parish, Louisiana. You got 5 years in 05. That was revoked in 12, and you got 3 years hard labor. Then criminal damage to a coin-operated machine, 3 years probation in 04. That was revoked also in 2012. Then you got 2 years criminal damage to another coin-operated device. That was revoked, and you picked up 3 years hard labor in 2012. Another 2 years probation. You received 3 years hard labor. It looks like you picked up 4 convictions in 2000. You were placed on probation in 04. Those were all revoked, and you get revoked in 2012 and get 3 years hard labor. So that's 4 more. That's 11. Then you've got 10 years probation. That was revoked for controlled substances. That's 12. Then monetary instrument abuse, St. John Baptist, 5 years revoked, received 5 years in prison. In 19, a second revocation of probation in 19, you get revoked out of St. John the Baptist Parish in Louisiana. Then convicted of monetary instrument abuse in 2016. And principal to attempted theft. Those are all convictions. So I've got 1, 2, 3, 4, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17 convictions. Not quite the 4 or 5. Not quite 4 or 5, is it? All right. There's no way you'd ever pay anybody back. We all know. You've never done it in the past. Okay, so the agreement here is whatever sentence shall not exceed 5 years in prison. So you're looking at no less than 2, no more than 5 years confined in prison. You could be placed on regular probation, sentenced to 5 years, and that would be suspended, and you could be placed on regular sentenced to 5 years, placed on regular probation for 5 years, and 5 years deferred or unadjudicated probation, I guess, what we're talking about. Although when we have a cap of 5, how do we work that? See, on a deferred, do they get? Can I assess 10 years deferred? Maybe, I guess. And that's a cap of 5 years imprisonment, right? So you can't give them imprisonment more than 5 years, I guess, is the way that works.
We could argue.
What's that?
Judge, the state is going to ask for the 5 years prison. When it comes to the offense itself, this defendant made 12 purchases at 9 stores over the course of 2 days. So it was a lot more than just seeing a backpack and keeping it. He did a lot of damage over 2 days. The court also just pointed out all of the convictions the defendant had, even when he was given the chance of probation. On several of those times, they all resulted in revocation. So it's obvious that this defendant cannot do probation, let alone be responsible for paying someone back. If you also look at several of the charges, Judge, they also either directly or indirectly relate to theft. So for example, his monetary instrument abuse.
I understand. I agree with you.
Okay. And lastly, defense counsel, I believe defense counsel pointed out defendant not being in trouble for a couple of years. What I see here is in 2014, that for monetary instrument abuse. It says that it was revoked in 2019 and he was sentenced to 5 years DOC then, which would account for why he hasn't been in trouble for a few years. It wasn't by his own choice. It was because he was in custody.
Somewhere.
Actually, I believe that was when he chose to do time.
Yeah.
So he chose to go.
Right, so, but I'm saying that that's what kept him in trouble for choosing to go and do time. So I'm asking us to sentence him to the full 5 years.
Go ahead, defense.
Judge, I mean, as I pointed out, I mean, earlier, it's been 10 years the last time that he had real issues. He owned up to everything. He went into prison on his own accord, did some time. It was a poor choice of picking up the bag off the street. He acknowledges that by virtue of pleading guilty, and he's asking the court for a probation.
Anything else you want to say, sir?
Yeah, well, I wasn't out looking for trouble, man. I just found her. Just ended up running into it.
Wasn't your fault, it was somebody else's.
No, it was my fault. I own up to it. I did it, but I wasn't out looking for trouble. Last time I was in trouble, I gave myself over to God. And I
So
was drinking
17 separate times trouble has found you without you looking for it.
That was when I was drinking and stuff. I stopped drinking since my last conviction at 14.
Anything else?
Oh, no, I just recently lost my mom Monday. I funeral was Saturday. I'm just trying to get out.
Well, yeah, that's what happens. Life goes on the outside. That's why it's always a good idea. If you make a mistake, you fix it. You've made 17, you can't seem to fix. And here we are with another victim. Earlier, you pleaded guilty in this case voluntarily, sir, to credit or debit card abuse. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in this plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of credit debit card abuse of an elderly person. And following this agreement, you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You shall, in the judgment, it shall be reflected that restitution is owed in the amount of $1,531.68 to Third Coast Credit Bank and $2,468.32 is owed and payable to the other victim, in this case, Clarence Holland, as named in the indictment. Those shall be part of the record in the judgment and ordered to be paid. Anything else? That is all.
All right, friends, let's change things up a little bit. Let's go to Louisiana. Let's give one of those a try.
Case, we are now at the Louisiana State Penitentiary. Warden, would you and your folks there introduce yourself for the record? Are they on mute? You got the warden in there with you, Mr. Sledge? Can you hear me?
Can you hear us now?
Yes, we can. So Warden, would you and your staff introduce yourself?
Deputy Warden Ashley Olivo.
Reginald Admiral, classification.
Carmen Shipley, under records.
All right, thank y'all for accommodating us today. And we have Mr. Sledge here with us. Mr. Sledge, would you introduce yourself? Tell us your name and DOC number.
Yeah, my name is Herbert Sled, 114914.
All right, thank you, sir. And you have counsel on Zoom this morning. Sir, would you introduce yourself? You're still on Zoom, sir.
On mute.
I mean, on mute.
Dal Solomon, I'm here for Mr. Sledge.
Thank you, Mr. Solomon. So, Mr. Sledge, let me just read some identifying information into the record, ask you to verify if it's true or not, and then I'm going to turn it over to Mr. Prater, seated to my immediate right. He'll take the lead on the case. Can you hear us okay, Mr. Sledge?
Yes, ma'am. Yes, ma'am.
Okay, good. So, Mr. Sledge, you're here today seeking a commutation of your sentence, and that is a life sentence for which you were sentenced in September 1986 in Richland Parish for a first-degree murder conviction. Is that information correct, sir?
Yes, ma'am.
Thank you, Mr. Craig.
Okay, Mr. Sledge, you doing okay today, huh?
Yes, sir. First, I want to post the board saying that I'm sorry for the crime that I committed. And I want to thank y'all for having me here this morning.
Well, thank you for being there. Well, this is your day, and so we're gonna give you a chance to tell us exactly why you're there, what you've done since you've been there that has changed your behavior, where we can trust you to get out. So you can take it from there.
Well, when I first come here, I was a young kid, didn't understand life. But since I've been here, I don't grow up to be a young man. I put God back in my life, my family, a lot of friends that's, helping me out too. But I think I've done pretty good.
Okay. What got you there?
Knucklehead kid, being a hard-headed kid.
I mean, what'd you do though? What's the actual crime that you charged with? And tell me about that.
Oh, well, we went for the borrow some money, pay some rent, and it didn't turn out the way I thought it was going to turn out. And
okay.
Kill
Well,
somebody.
we'll ask some questions in a little bit. Warden, tell us about this fella. How's he acted since he's been locked up?
So he served about 39 years on his sentence. He's a Class A trustee that lives at Camp F, which is our trustee housing unit. He's worked in the carpenter field with our maintenance crew, and he's currently with our welding crew. Looking in his record, he goes to different areas outside of the prison, helps set tents up and things like that, like at the governor's mansion and stuff. He's had 30 disciplinary reports, the last one being in 2014, which was a Rule 7, and it was an incident in the kitchen with the kitchen employee. He's completed 100 hours, anger management, substance abuse, thinking for a change, Malachi Dead, taking personal responsibility, and its tighter score is low.
Okay. All right. Well, thank you.
Well,
Mr. Sledge, we've got some folks that want to speak on your behalf. And we got a number of people. Let's see, there are 6 people that are here. 2 of them will speak on your behalf. Marilyn Wesley and Patricia Harris. And we also have here Tornado Sledge, Antonio Grace, Jacqueline Sledge, and Sequoia Sledge. And then on Zoom, we're going to have Lavelle Solomon, your attorney, who will speak last. And then also we have on Zoom, but not to speak, Lavelle Sledge and Alvanisha Sledge. So we'll go ahead and Mr. Solomon, we'll save you for last if that's what you'd like. Does that sound reasonable?
That's fine.
Okay. All right. Let's hear from Marilyn Wesley, your cousin. Come to the podium, please. Speak loudly and limit your remark to just 2 or 3 minutes so we can get the gist of what you got to tell us about it.
Okay, I am Marilyn Wesley, and I've known Hubbard since 1970. Matter of fact, we're in the family. And he was just a little boy. And I was a teenager. And we lived across the street, across the ditch, and growing together. And in the 3 years that I saw him grow into a young man, I never known him to get in any trouble or anything until this incident happened. And I really think that he would be an asset to society. I think that that our town would benefit for him being released. As he said, he has rededicated his life to God. I believe he would go to church. I believe he would not be be friends with people that he was with that caused this incident. I believe that he has paid his debt to society. I really do, and I believe he's a change. And so we have people that are willing to help him get a job. He will have somewhere to stay. There will be no reason for him to go astray again. And now he is much older. He's had plenty of time to think about what has went on in his life. And so I think he's gonna be all right.
Okay,
All right.
thank you. We appreciate that. Miss Patricia Harris, the mom. Oh, sister? It's written down, Mom. I didn't make that up. That wasn't, please forgive me.
It's okay.
What was, that was supplied to me. You look like his child.
Well, he practically raised me. Our mom passed on, well, when I was one, so all of my older siblings and him and all of them took care of me. Well, I'm Patricia Harris. I'm the baby of the clan, as I stated. I've been on this journey with my brother since he's been incarcerated. I do not condone his behavior of what transpired happened. And he is truly remorseful because he expresses it every time we have a visit. We pray about it, and I always share with him the scriptures and incline him and encourage him to trust God and to ask God for forgiveness. And he demonstrates that. He demonstrates that he is truly remorseful about what transpired. I believe he's a changed man because I began to see a totally different person throughout the years. Like I said, we've been on this journey with him ever since he's been here, and I've been big enough to drive and come and see him. Not only have I, but my kids as well have been on this journey with him. I feel that my brother will be a valuable asset to the community by sharing with other young men and young people about the journey that he was on, that he took, hoping that it will deter them from having to take this journey. I have been talking to juvenile correction centers and farms upon his belief that he can come in and testify and share with them, and hopefully it will give them a beacon of hope as to, hey, this is not the road that I desire to take. So I want to thank you all for allowing us to be here today and have us here. I believe he has truly been rehabilitated. I really see it in him. And once again, like I said, I do not condone his behavior, nor do I uphold him in shape or fashion. My part from here on out is to continue to support him. Upon release, he will become and stay with me. I don't do anything but church work at home, so that and go to work, so that's all we will be doing anyway. But like I said, I really do feel that he will be a valuable asset upon this release. And I want to thank you all for your time.
Thank you, ma'am. Appreciate that. Mr. Solomon, would you take it from there?
Sure, thank you. I'm married. I'm not used to having the last word. But Mr. Sledge was 20 years old and a first offender when this occurred in 1986. He was involved in an armed robbery that resulted in his death. There was some question as to whether he shot the individual or his co-defendant, Willie Robinson Jr. did. They were both charged first-degree murder. Mr. Sledge, about 8 months after the incident, his arrest in January of '86, pled guilty in September of '86 to first-degree murder, but with life in prison rather than the death penalty aspect. He's now been in jail just about 40 years. It'll be 40 years next month. As the warden indicated, he's a Class A trustee. He hasn't had a write-up in 11 years. The bulk of his write-ups were back in the 80s and early 90s. He's participated in any number of programs and classes, and he's earned his trustee status and earned to be able to go off facility to help at other facilities, the governor's mansion and other places with work projects. He's 60 years old now. It would seem that if he could re-enter society, he could add something to it. He's a carpenter. He has skills in welding. And he's certainly put a great deal of time and distance behind what happened here and being a 20-year-old, a 20-year-old doing stupid stuff, and tragic. And it's wasted a number of lives, his family's, 40 years of his own, and another individual also. And I would hope that he could be released so he could try to make amends and get some sort of life still.
Okay, thank you, Mr. Solomon.
Thank you.
All right, Mr. Sledge, let me ask you, who pulled the trigger?
Willie.
The other fellow?
Yes, sir.
Okay, that's what I got out of the reports, but I didn't, out of your statement and all of the reports, I guess. You didn't mention his family. What do you think about his family? I'd like to hear see if you're remorseful. I was glad that your sister brought that up.
Yeah, well, as I was a little kid, I apologize for what I did. Like you say, I took 40 years out of my life and 40 years out of my family life, and I hurt the victim family. I'm so sorry. I've been thinking about that for the last 40 years of my life.
Okay. Yes, sir. Yes, sir. Actions have repercussions, don't they?
Yes, sir.
All right. Pamela, do y'all have any?
Just a couple of things. I know that you say, and people often say, you were 20 years old, weren't you?
Yes, sir. Yes, ma'am. Excuse me. Yes, ma'am.
You weren't a little kid. When I think of little kids, I'm gonna think of a 14-year-old. You were a grown man. Now, your victim, am I correct? He was 84 years old?
Yeah.
It'd be somebody's grandfather, things like that. Totally helpless against a 20-year-old. Well, in fact, too. So when you're thinking about it, maybe you just can't express it. But those are the types of things that when a person's really remorseful, they think of the individuals.
Yes.
So yeah, you do leave that out of your conversation. All right, that's all I had to say.
Yeah.
I don't see any other questions. I think we're ready to vote. Mr. Prater.
Yes, I've looked at your record since you've been incarcerated, taking into consideration your age when this occurred, the fact that it went bad, the fact that you're and you're like a lot of people that we run into, you're not real articulate, because just some folks are and some aren't, and you just don't put your feelings into expressions. But like I say, I got to give credit to your sister about bringing up the fact of how remorseful you were, and I can see it in you, and I think you've done a lot since you've been there. The facility feels like that you've done well enough to be trusted on the outside on a number of projects and a number of things, and so my vote is going to be that your sentence be commuted to 99 years with immediate eligibility for parole.
Mr. Freeman.
I concur with Mr. Prater.
Mr. Tillis.
I concur with Mr. Prater.
Stapleton.
And I concur with Mr. Prater.
As do I, Mr. Sledge. So on your behalf, sir, we're going to make that recommendation to the governor. Good luck to you.
Thank you.
Congratulations.
Thank you.
All right, so that one was interesting. So commuted from life to 99, which makes him parole eligible if the governor agrees with that. So not getting out, but there's a potential pathway maybe. Very interesting. I hope you guys had fun today. I did. This was a good start to the month, and hopefully we can continue to have good shows like this, good hearings, just the right amount of grump from the judges. I think it was good. So good. We'll do it again tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members. A couple of things with the channel before I let you go. You'll notice that visually we upgraded some things, not only for the live show here, but for our thumbnails and stuff like that, making some evolution in how we look, always trying to get just a little bit better. So hopefully you all enjoy that. Also, if you go to the YouTube channel page, you will find now that every judge, unless it's like a one-off thing, has their own playlist now, every single one of them. So if you want to binge on a certain judge, I've made it very easy for that to happen now as well. So hopefully I'll appreciate that. But again, we'll be back tomorrow. All sorts of links in the chat for places you can go shop and support the show. Please consider doing that, especially on Cyber Monday. While deals are still there. Courtroomfiles.com and artandsoul.etsy.com. Check those things out. But yeah, go have yourselves a good day. I'll see you tomorrow. Take care. God bless.